I'm on interim. Interim may be continued.
25.
25. Would do it.
Still not received.
Interim may be continued
Not received.
after vacation, madam. With the review
15th of July.
of license.
It will be continued.
Next mention item number 22, bail hearing method. I have been instructed not to press the case.
Not to press.
Not to press.
Administrator and counsel the petition. Also administrator keyboard code in an submitted by Mr. Taruka as per instructions. He doesn't want to proceed press with the petition and accordingly pay for withdrawal. He will disposing on withdrawal.
Obvious.
May I please, Lordship? Lordship, I beg to mention item number 33. In this matter, I am appearing for respondent number 2. Yesterday, I filed written objection.
30,
The same, sorry,
30,
36.
36.
Same may be called for.
You are for whom?
Respondent number 2. Yesterday, I filed written objection. Is not
Your
on
prayer,
record.
what is your prayer? Should be called for?
Yes.
Achha. Call for Koidiba.
May I please, Your Lordship? I became inside item 15, my lord. I have checked the record, my lord. Service is awaited, my lord. On 6/6/25.
18. Services awaited.
Yes, my lord. 15, my lord. Item number
Oh,
15.
sorry, 15.
1/5, man.
Ah, yes.
Can TCR receive?
TCR has been received, my lord.
Mr. D. Bora, then also. Mr.
Can be after 2 weeks.
As per the office note, the service is still awaited for the response. Let the service be awaited till next date of this. However, scan copy of the case report already. Yes, waterfall when it can be.
My lord, on 16/7/20.
16/7.
16.
Obvious.
And also the
Here for the informant, then many name of the 5, 7, 8 numbers of the advocates have been shown as in the cause list. They are representing the informant. No?
we are representing the
No, you are representing the petitioner, the other
Yes.
counsel. We have not received the case diary yet.
case diary.
You are on interim.
Yes.
Issue remained interim. Yes, protocol.
On my lord, 16/7.
16/7 interim be continued. Next step. Okay. Yes.
May it please, Your Lordship. Lordship, I beg to mention item 44 of the daily list. There's some difficulty conducting this matter today. May this matter be listed after vacation? Item 44.
44. And you are for the
Petitioner, Lord.
petitioner.
Bail cancellation, Lord.
Achha, achha. With the consent of the still and counsel appealing for the petitioner paid for an adjournment stating that the conducting counsel. Who is the conducting counsel?
Yes, Nawaz, Lord.
Conducting counsel S. Nawaz has some personal difficulty. Prayer allowed. List the matter accordingly. After vacation, it will be listed at
After vacation.
16 or 15.
On 16.
Keep your bill.
Item number 32. 16 or 15 is there.
Yes,
34.
protocol 34. What is the position?
34 case diary not received, man. Petitioner is in interim.
City not received. Issue reminder. Yes, on which date?
On 17/7, man.
17/7. Interim be continued till next date. Criminal. Make a mention before court number 8. Pardon? Or otherwise you can be approach the registry also. They will accommodate it. But we are not taking the mention matter, no? That's why. Because senior bench is of court number 8. That is the reason.
That is wrong. Item number 12 and 13. And for that fellow, city fellow.
It's a charge sheeted case or no?
No, no, fellow.
But you are interim. You are interim.
I am on it.
In both the
In both the cases.
C did not proceed. Issue reminded. Yes,
Yeah.
On 17/7.
17/7 interim be continued till next day.
It seems to continue.
Yes, yes, sure. Yes. From where? Kamalpur.
Kamrup.
Kamrup.
Yes.
I think that's on 14/5. That could be 8 days.
But I don't think we have any date prior vacation. Is there any?
22nd.
22nd or 23rd? It will be on 23rd only. Oh no, 23rd many matters are 22nd, na?
22nd.
22nd. CTB call.
Point eight of draft screen has been required for this one. This is the which is in the period quantity. Document was registered on 8/2026.
CD Lordship.
Also clear
24.
Before vacation, we are managing 23rd of this month. 23rd.
Can copy it along with notice. Solicited that.
It's charge sheeted case. As per your instruction, what is the stage of the case? Is the evidence is already started? Not yet. We are going to issue notice and that part the scan copy will be required. Okay. Happy Begum Laskar. You are MS?
Ada.
Hard MS Ada, still on council of deputation, also hard MS SH Bora, Dilanet edition PP, appearing on behalf of state respondent. Issue notice to the respondents. However, no formal notice is required to be served on the state respondent number 1. Notice be issued to the respondent number 2 through the jurisdiction police station, routed through the office of the registry and the public secretary. Also call for the scanned copy of the TCM. Registry will do the needful. The matter will be accordingly listed. Prior vacation the lab. Prior vacation may not serve your purpose. Huh? No, whatever.
Lordship, on the very reopening day on 13th of July.
Very reopening day on 13th of July. Hmm? Is a charge sheeted case?
Yes, Lordship.
Scan copy of the TCM along with the case diary be called for. Registry will do the needful. List the matter. Yes,
After vacation, NDPS commercial quantity, Lordship. Commercial quantity.
maybe on 14th, I think.
14.
14th. Yes, after vacation 14/7.
14/7.
No, commercial quantity is there. 14/7. Yes.
They are not paid.
Oh, अच्छा.
Petition CDB call.
Heard Mr. M. Khan, the learned counsel for the petition. Also heard MSSC Chopra, the learned edition PP April of state response. CDP call for and also 2 notice to the respondent number 2 through the distant police station routed to the office of the registry and the public. Do you think it will be can be listed before vacation? Because we have to see the report also,
Yeah,
service report.
service report
All
is also
chance may be given that because
25 and
on 25th,
25/6.
20.
I
Yes.
before you coming before my limited protection, my lady, that the transit anticipated daily protection, my lady. The case has been registered in 63 Division Police Station, Jamnagar, Gujarat, my lady. And it is a sharp notice under 35 Close Bracket 3 of DNSS for its appearance, my lady. And some of the sections are non-bailable, my lady. People are ready to appear. They have 1 month time has been given. And people are received notice on 4th of this month, my lady.
Where is the notice?
Notice is page number 7, my lady.
Oh, I think no date is there after 30 days only. Here it is a before me police station on 30 days after receiving the notice. So when you have received the notice?
4th of June this month.
Yes, Miss Bora.
Lordship, no date has been there. No
There's
date.
no date. I don't know why.
Date.
Only after 30 days of
Yes.
receiving of the notice. That is generally
That has to be mentioned.
that
all
has
the
to be
time.
mentioned and
Yes.
generally it mentioned.
Yes.
We find mentioning of the date also on or before such and such date.
Yes.
It's related to cybercrime.
FIR number so and so and dated 4/3/2026. That is there.
But
Poetry.
That is there, but the notice date is not mentioned.
Yes, anything to submit.
Lordship, if transit bill, then for a limited period.
Then obviously for a limited.
until I approach the appropriate court, my lady.
No, no. Well, it did not. At least we can keep 2 weeks.
Yes, Lordship.
2 weeks within
2 weeks. Till then only. Lordship.
Till then, only.
Yes.
Okay, we'll pass the order after 2 weeks. We'll be
Lot.
under transit
Lordship.
anticipated. Otherwise, your petitioner is guilty of that offense or what?
Not my lady, they exactly cheating and some sort of my lady, the identity cheating, different property. Offense are mainly 3 year maximum punishment.
No, no, no. Your petitioner is guilty or not?
Only
What is your submission?
notice under 35(3) only
35
issued,
cases
Lordship.
in my-
No, I can understand.
Yes.
Whether there is any implication,
As
there is
per
any
the
apprehension.
description, he is not guilty, my lady.
Then
He is out.
why the protection is with?
Why you need the protection then?
Yes.
Okay, I'll pass the order. Yes.
12
Ah.
to
Priya Kumari in Priya Kumari Indoria niki? Priya Indoria. No, itu case down. Priya Indoria.
for bail hearing item number 14.
Your blood. I'm allowed to take steps.
perhaps steps not been taken by the petitioner.
Oh,
It's a husband, it's my lord.
It's a POCSO matter, Lordship.
ah,
As
yes.
per practice direction, he has to take steps.
Ah, yes. You are Mr. N. Borwa?
Yes.
Hi, Mr. N. Borwa, the learned counsel for the petition. MSSH Bora, the learned additional PP have been posted responded from the office note as well as from the submission made by learned counsel. It is seen that the steps has not been taken for the respond number 2. In view of this, the petitioner is hereby asked to take steps for the respond number 2 to jurisdictional police station related to the office of the registry and the public prosecutor. Scan copy is also awaited, na? Oh, I received. Scan copy of the teacher has already been received.
Perhaps it is, that is there.
Yes, we have received.
Yes.
When it can be fixed.
Lordship,
Before
as per the
vacation will
convenience of
serve
the
your
court.
purpose. I don't think so. I'm just asking you. Before vacation, though, I don't think so.
Not only because the ticket was only the matter
24 months, 24/6.
16.
I mean, okay. What is the office notes? What office note
Lordship,
says?
as I have taken instruction from my office, so we have not received the copy of notice yet, Lord. From registry.
I don't know, but here is the office note of 27/5.
Lordship.
Your office has already received.
No, Lordship, notice has been issued, but we have not received. I have taken telephonically.
No, your seal is there. You have already received.
Lordship. But
That's what from seal only I'm saying.
Yes, but I have taken instruction from our office. No such notice has been received.
And Bahawazans. Generally, it should not
17.
because your seal is here.
Lordship, anyway, for the time being, Lordship, this matter may be taken after some time.
Otherwise, we have not received any report till date.
Yes.
So we may such pay. Pass any instructions to you to just inquire because
Yes.
we have not received back the notice till date.
Yes.
And you also inquire whether your office has received or not.
Lordship. 17, huh?
I heard Mr. H. Ali, the learned counsel for the petition, also heard MSSH Bora, the learned additional PP appearing on behalf of state respondent. Scan copy of the teacher has already been received. However, it is seen that the service is still awaited for the respond number. Same in the MS Bora, the learned additional PP, however, submitted that on inquiry, it is found that their office of the public prosecutor, the office of the public prosecutor has not received the notice issued to the respond number 2. In that context, MS Bora, the learned additional PP, is hereby asked to make an inquiry as to whether the office has already been had received the notice, as the seal of the public prosecutor is already reflected in the note sheet. Apart from that, the additional public prosecutor is also hereby asked to take instructions in regards to service of notice on the respond number 2, if their office has already received the notice. List the matter accordingly. What is the stage of the case at present? Evidence started.
Already 4 cases.
Victim is also examined.
9 months, 49 months. There.
Now see, prior vacation, I don't know whether it will come back or not.
Right?
24/6. What is 18, Bora? CD receipt?
Yes, there is. As of 49 days.
How many days? 49.
49 days.
Okay.
The fact of the case is that upon taken information received by the police station, and there's place of occurrence, that is Amrit Nagar, and on 14, they entered in a rented house owned by the Lutfa Rahman, and upon there they detained 8 persons. 8 persons were playing with some Thereafter, they have all the each person were arrested and they have put the in the bar. Thereafter, on 23, the present petitioner was arrested. And thereafter, the petitioner filed bail for the learned court bail, but the learned court was partially rejected. And now the my case is developed. The name of the present petitioner is not in the affair of the court. And secondly, nothing has been recovered from the present petitioner. The petitioner, probably why the petitioner was arrested, because the petitioner is running a tile, sanitary and tile shop, in Pulavanga place, and this is doing business. Some customers come here, probably some customers from this route also go in there, and upon phone call the investigation, they found some things that is there. But nothing has been recovered. My client is not, the petitioner is not involved in this crime. So as of today, 49 days, I may be released from this, and other 8 persons were arrested, and 7 persons have been released by the honorable court. So I'm saying, sorry, so released by court is then.
The case
Period is proceeded. Just then,
Yes, what?
the case they received, my lord, as per the secret information that some cyber fraud activities is going on from a particular place. On that, my lord, on the basis of that information, the informant along with the higher police officials, my lord, raided the place of occurrence, my lord. That is actually in fact a call center, my lord. From that call center, my lord, all these, my lord, cyber fraud activities is going on, my lord. And how these accused persons are involved, I will point out to your lordship. And during that search, my lord, mobile phone is the main, my lord, medium through which, my lord, all these, my lord, activities is going on. To tell, my lord, 7 numbers of Android mobile phone, 7, my lord, keypad mobile, and thereafter, my lord, 5 SIM cards, 6 debit cards, and various, my lord, bank accounts, and my lord, debit cards of other account, my lord, Caesar list, my lord, detailed Caesar list is available, my lord, in the case diary. And how these accused persons are involved in committing the offense, my lord. Initially, they make, my lord, random phone calls to various, my lord, victimized person. Thereafter, my lord, your lordship, I may be allowed to read a particular portion of the, my lord, how they are. After interrogation of the apprehend individuals and upon examining the evidences seized on the spot, it came to light that the individuals were operating a cyber crime racket which involved in cheating many individuals in the name of offering loans and collecting huge ransom. These loans were offered via phone calls. So, my lord, mobile phones is the main, my lord, offending, my lord, while in this case, total 14 numbers of keypad mobiles also, my lord, recovered via phone calls, where the apprehended persons uh, call, dial random numbers and offered the customers loans. They disguised, impersonated them as employees from Bajaj Finance. After that, they would lure them by saying that a loan up to 5.5 lakhs has been approved for them at a very minimal rate of 5%. Upon which they agree and then ask for their personal documents. And if in case, my lord, they provided, initially they made the phone calls, thereafter they asked that particular person that you loan amount of rupees 5 lakhs already, you will get an amount of rupees loan of 5 lakh. So you will have to provide your documents. Suppose if that person agreed, then they immediately ask them to pay a particular amount of rupees, suppose 3,000, you will have to pay that for providing insurance as a processing fee. And if somebody paid that amount, immediately thereafter, my lord, he will not find him again. But if he made replied call, then he will never find that man in that number. In this manner, they were running a call center in that particular place, my lord. And that particular place is the residence of the present accused person and his brother, my lord, where the entire call center is running by all these accused persons. And from that call center, all these random calls were made by these accused persons. And in the name of, my lord, Bajaj Finance Company Limited, in the name of providing loan, thereafter, my lord, they took an advance amount of rupees, suppose 3,000, 2,700. And my lord, while they, my lord, received that amount, immediately thereafter, their phone calls, my lord, switch off. There are many numbers of, my lord, victim statements is also available in the case diary, my lord. And initially they were operating these activities in Kerala, my lord. From their statements, my lord, it reveals, and thereafter they are, my lord, individually operating from this call center, which was owned by the present accused persons and his brother, my lord. And regarding their statements of the accused persons, also specifically stated that the present accused person is the who provided all these mobile phones and SIM cards to these accused persons to continue all these activities. So in this manner, they are collecting huge amount of money from various victimized persons, my lord. And some of the statement of the victimized persons also available in the CD, my lord. This is a racket, my lord. Cyber fraud racket is going on there. They were running this call center from the, my lord, place provided by the present accused person along with his brother.
Page number 11, there are 8 active persons. They were arrested, and nothing was required. Everything was required. Those name, they police have been recorded by name. Suppose who have been said. And another thing, Lord, if the place of occurrence where the 8 arrested persons committing their cyber fraud was not the residence of the present accused person. That is the residence of one Lutfur Rahman. That is recorded in the FIR law. So if you want medicine.
Lutfur Rahman is the brother of the present accused.
No.
Their statement is available from.
No, Lordship, he is not the brother of the present PT.
And medium for committing all these offenses is, my lord, mobile phone. So, my lord, keypad mobile phone at this point of time, 7 keypad mobile phone, Android mobile phones. And through that mobile phones, my lord, they are involved in committing these offenses. So mobile phone is the vital evidence, my lord, in this case. And mobile phone is the, my lord, main medium through which, my lord, they committed all these offenses. And SIM card, debit card, my lord, everything.
And what about the progress of the investigation? What is it?
Investigation is still going on, my lord. Some of the accused persons, my lord, not yet arrested, my lord. Some other accused persons are yet to be arrested, and they're. And from the, your lordship may kindly peruse one regarding one of the statement of the accused persons, and other statement is also regarding. He has now stated that Rafiqul, one Soriful Haq. Soriful Haq is the brother of the present accused. From their statement of the accused persons, my lord. Thereafter also there are many statements, my lord, wherein it is specifically stated that the present accused and his brother is the main person who has provided those mobile phones, SIM cards for committing all these offenses, my lord.
So it seems that India, some of the witnesses have directly implicated you that on your house as well as the house of your brother,
Also.
all this cybercrime was committed from the call center which was there in your house. And that apart, you are the person who used to provide all the mobile handsets and all for doing that cyber. It's a case that you are on 49 days behind the bar. That is the only issue, but case is still under investigation.
Yes.
Is it a 60 days period? What happened?
Because earlier they are operating from Kerala, other statements also available. Now, my lord, they are through this organized racket, they are, my lord, operating from that particular place, call center, because network is very wide, my lord. It is not that only in that particular state of Assam, my lord, their network is, my lord, widespread, my lord. Not only, my lord, they are by sitting there regularly, they are making random calls. Suppose, my lord, they are making random calls to 200 persons, and suppose somehow they manage to, my lord, get my lord is my lord assure some of the, my lord, suppose 10 persons, my lord. Suppose 10 persons provided them all these documents and also paid an amount of rupees my lord 3,000, then per day they are getting, my lord, 30,000. Out of 100 phone calls, 300 phone calls, my lord, they are getting, suppose, my lord, then that in that manner also, how much money they are, my lord, earning every day, my lord. And that their network is also not in a particular place, because through medium is of committing all these offenses mobile phone. From mobile phone from anywhere, my lord, not only in India, there are, my lord, some now it is also founded from Assam, my lord, in Morigao district, Borpeta mainly. These accused persons belong from Borpeta. My lord, there, my lord, network is very huge.
49 days.
Only ground, my lord, or length of detention, my lord. Otherwise, my lord, he is allowing all these accused persons, allowing the entire his residence for running that call center, my lord. From that call center, my lord, all these activities are going on. From that call center, they are calling, making phone calls. These are the difficult.
So 11 days more. That is only the case. Anyway, you are Mr. R. Islam.
RST.
Mr. R. is done petition. Also heard report BP applicable. It's an application section so in connection with so next submitted by Mr. Islam that a present accused petitioner is in he has not committed any such offence as there. He is not an FIR named accused, nor anything has been seized from his position by the investigating officer. He was also arrested subsequent to the arrest of the other accused persons, only on the basis of some statement of the co-accused. However, he is in custody since last 49 days, and thus there was sufficient opportunity to interrogate him, keeping him in custody. The other co-accused persons have already been granted bail by the court and Charles Court, and hence, considering his length of detention, he may be released on. Next one, Mr. Bhattakur. The learned edition 50 days objection submitted that at the time of search and seizure, present petitioner was not available in the place of occurrence, which is a call center, and the entire call center was running from the house of the present petitioner, which house of the present petitioner and his brother. But he submitted that the the modus operandi of in this case is that they used to call, make random phone call to different persons and offered for loan from Bajaj Finance, and in that context they asked the victim to deposit some amount of money for clearance of the loan, and then when the victim deposits money, thereafter they disconnected the phone call, and thus they misappropriated a huge amount of money through the disseminate. He further submitted that the present accused petitioner is very much involved in the alleged offense, under whose guidance basically the entire cybercrime and the network was running. And that effort, he is the person who used to provide the mobile handsets to the other accused person who was operating the network from the rented premises of the accused petitioner. He further submitted that this accused case is still under investigation, and some of the culprits are yet to be named in connection with this case. Next, hearing this submission made by learning counsel, also perused the case diary, and it is seen that some incrementary materials have already been collected by the IO against the present petition. And as per some witnesses, the entire racket was running from the house of the present petition and his brother. However, it is seen that the case is still under investigation, and probability of furnishing the charge sheet within 10 or 11 days is not probable, as the investigation is still under process. So, without going other detail into the merit of the case, only considering the length of detention undergone by the accused petitioner, this court is of opinion that I was sufficient opportunity to interrogate him, keeping him in custody. And hence, I find it a fit case to extend the privilege of bail to the present petitioner. However, with a direction to him to extend his cooperation as and when it is required. In default, the bail order may be cancelled. And if any condition is violated, the bail order may be cancelled. To the satisfaction. Is this case of from which place?
Borpeta.
Borpeta, CGM Borpeta. Only considering length of detention and other accused persons have already granted bail, that condition we have enlarged you on bail. There will be some direction to appear before the IO as and when it will be required. Abide by all the conditions.
Nine. 19, my lord, as per my instruction, my lord, charge sheet submitted in this case.
The allegation is that in my vehicle, the number plate which was, that is the number plate of the import. That is the allegation. When accordingly informed the police, I was taken into custody. I mean, the custody for 67 days.
67.
You will face the trial or for that. Only just regarding number plate.
In regards to merit, I think Kothakuri may not be in a position to submit anything.
Yes.
Considering length of detention also, so only that much.
What was the allegation you submitted?
Allegation is that in my vehicle, the number plate which was affixed, that is the number plate of the informant vehicle. That number plate was registered in the name of in this vehicle. The allegation that with same number plate, I was driving the vehicle was in the name of my wife. So,
But suppose I'm saying that you have been using the number plate of the informant, which is in your name of your wife, but there was no number plate or no registration number for your vehicle.
My vehicle, I am running and lordship travel agent. That I give my vehicles to self-drive lordship to other people on rental basis. And accordingly, lordship, I have also lodged one FIR that my vehicle has been stolen. So that FIR, your lordship will also file your offense in the forwarding report. Lordship.
Vehicle has been stolen.
Lordship. So I have already lodged one. That page 15, your lordship will find the grounds of arrest. But as this case was lost, police says that I have falsely lost the case. Without investigation, how they can say that I have lost case?
No, but yes, okay, you have lost an FIR. My question is that suppose your allegation against you that you've been using the number plate or registration number or number plate of the informant. But I'm saying, where is your registration number?
That registration I have enclosed here also.
Your registration number is there?
Different.
Different.
Admittedly, that is page
Then
15.
why you used your the number plate of the informant?
vehicle was stolen. That regarding that already I have lost one. That page 15 will
No, page 15 is your FIR.
so forwarding report. In the forwarding report, it is mentioned that I have already lost one case regarding that stolen. Page 15.
Page 15, which para?
Ground number 5, kindly see.
The accused person lost a false FIR.
How they can say
But
that
vehicle
it is
number
false
is not
without
there.
investigation and
Vehicle number is not there, my lord. Only section, my lord. But on the basis of while lodging the FIR, my lord, what vehicle number he has mentioned, my lord, as pointed out by
That is still not there.
not there.
Uh,
As your lordship has pointed out, what is the registration number of his?
your registration, you don't have any registration number.
I have next. That
Which page?
will find page 21. Page 21 and 22. I am owning two vehicle lordship, both registration lordship I have received. 22 lordship may kindly see. That registration number is there. AS01 top portion lordship. So that second vehicle number is at page 22 registration certificate. I have two vehicles I am on for lordship that agent, that travel agent. Both numbers I have.
So you are running a travel agent.
Yes, sir. Whatever is there, you will face trial notice. For that, 7 days already. And how police of dispute PS can say the matter which is pending for both the PS is a false. I lost the case before.
Because they made an inquiry.
Yes, they can make an inquiry, but on the same day after arresting me, on the same day they have mentioned it in the forwarding report.
But my lord, at this point,
Prompt action.
yes, well, otherwise at this point of time, only basis of the FIR, my lord, it is difficult to say anything, my lord.
Bank of
On
detention
what
notice.
basis?
At best length of detention.
Yes,
Yes. I heard Mr. A. Ahmed, 99. I heard Mr. A. Ahmed, Ilani Constitutional Petition. Heard. Mr. P. Bottom, Ilani Additional PP at Payment. It's an application, section so and so, next so and so. Case was fixed for case diary, but it is submitted by Mr. Bottom. That case has already been charged. Right, CS number, yes. CS number is
CS number, my lord, 260/26, dated 30/5/26.
so and so. In that
This
context,
report may kindly be kept as a part of the record, ma'am.
the report received from the IO may be kept as part of it. In that context, Mr. Ahmed, the learned counsel for the petitioner, submitted that the accused is in custody since last 67 days, and considering his length of detention, the bail prayer may be considered. However, he will face the trial by appearing before the learned trial court below on each and every date. Further, Mr. Ahmed submitted that the only allegation brought against the present petitioner is that he was using the number plate of the informant, But the petitioner, apart from that, there is no other allegation against the present petitioner. However, it is the case of the petitioner that he is running a travel agency wherein two vehicles were given on rent, and out of which one vehicle was stolen, and in that context, he also lost an FIR. Before which police station?
It's the PS case number 53 of 2023.
53.
Of 2023.
He lost an FIR before Basista police station, which has been registered as Basista police station case number 53 of 2026. But without making any inquiry to that regard, the petitioner got arrested in connection with this case. He further submitted that the two vehicles which were under his agency has the registration number and that has already been annexed along with the petition. Next, Mr. Bott, an additional PP submitted in that cannot say much about the merit of this case as the CD is not available for the court. Next, considering the submission made by learned counsel without going other detail into the merit of the case, only considering the length of detention already undergone by the accused petitioner. This court is of opinion that further custodial detention may not be required. Accordingly, I find it effective. It is a case of which place? Dispute.
Not was it dispute here? Petition is Kamrup.
CGM Kabutai.
Okay.
Regular 16 as per my instruction, my lord. Service completed, my lord.
Service completed.
Yes. File to go.
Mr. Hawk, this service is completed.
Yes.
We are going to appoint immediately today by. Heard Mr. F. Hawk, the learned counsel for the petition. Also heard Mr. P. Borden, the learned additional PP applicant respondent. It is submitted by Mr. Waterput as per his report. As per the report of the IO, the service is already completed on the respond number. However, no one has represented the respond number 2. In view of that, later amicus be appointed to represent the respond number 2. Accordingly,
This cannot be.
accordingly,
My lord, in this case, one other instruction also I have received that in this case already search sheet submitted.
oh,
So scan copy has to be called for. My lord. You will not.
accordingly, MS Srimati Trisi Das is been appointed as an amicus to represent the respond number. Further,
Yes.
it is submitted by Mr. Waterput that the case has already been charged.
CS number 115/26 dated 27/5/26.
Dated
27/5/26.
in view of this, let the scan copy of the TCR be called for. The registry will do the needful listing matter. It will be, it has to be listed after vacation. I think otherwise, I don't think it will be listed.
4 years.
64 years.
4 years.
Very nice. Huh? That to section 6 POXO.
Authorized by the taking case
No, maybe I don't deny it, but
Well, this report,
section 6 is
this
there.
report may be kept as a part.
So report may be kept as a part of the record.
44.
We'll try, let us see. 20. 24/6. Because what had happened that this case is charged sheeted, so we are not in a position to say as to in which court, before which court it is pending. So it has to be inquired, make an inquiry, and then only the scan copy may be called for by the registry also. And that's why I thought. Anyway, we'll try. If it reaches, then it's okay. If it doesn't,
Can it come from the POCSO court from Aditya law?
there's one only, na? Then in that case, okay. Then.
Deeply other. 20.
20 my lord, case diary not received. Petitioner is in interim. My lord.
We want the same. Is there not received, na? None appears on call for the petitioner. Or Mr. P. Watt would elanate additional PPF. CD not received. Issue reminder. However, from the record, it reveals that since last 2 consecutive dates, the petitioner remain unrepresented. Unrepresented. Oh, no, what are they? Night. They are not, after getting the interim, they are not appearing, Mr. Bottom.
Yes, my lord. Earlier also on 24/4 they have not appeared, my lord.
No, not appearing, yes. Now see 22, they got the interim on 10/1. After 10/1, the next date was on 20/02.
Yes, my lord.
They remain absent. Then on 17 also, most probably they were absent. Then on 24/4 also
No,
absent.
absent, my lord.
And 12/5 also they are absent.
My lord,
We are
this-
giving a last chance, otherwise we'll close the case.
Yes.
In that. Issue reminder. Release the matter accordingly on 17/7/2026. Interim be continued till next date of listing. However, considering the absence of the learned, absence of the petitioner, the consequential order may be passed in the event of absent if the petitioner remain absent on the next date of listing. Yes, other side is not there.
My lord.
Ms. Scan TCR we
Yeah,
have received, na?
Scan this receive, my lord.
And on the last occasion,
There's
Mr.
a F-
SP Chaudhary was there.
My lord. There's the absconder charge sheet.
Absconder charge
My-
sheet. Non-appearance call for the petitioner. Part Mr. P. Sharma, the learned additional PP, appearing on behalf of state respondent, and MST Parashar, the learned amicus, appearing for the respondent number 2. Scan copy we have already received, na?
We received, my
Scan
lord.
copy of the TCR has already been received. When it can be listed?
My lord. After reopening.
Let it be after vacation.
My,
On 14/7?
my lord.
Let it be on 14/7. Hey, Burwa. I have to click the case of the password. Code. Yes, what is 24?
24 CD received, my lord.
My order has already been passed. We are listing it on 14/7. It's a charge sheeted case, I think. Scan copy we have already received, which is listed on 14/7.
Idea of it.
You have taken steps.
In terms of idea of it, we have taken steps that is not to represent it as we have got it.
Go to item number 24. Yes, the case diary received, my lord. I have received the case.
Steps are received, Lord, and we have filed. I have filed wakalat freshly, Lord. Yes, wakalat.
Oh,
Yes.
yes, sir, that means you are going to represent the respondent number 2.
Yes.
Achha.
Case diary also received.
But sometime maybe we have to file the wakalat. We'll have to obtain the copy.
Achha. Otherwise, you are on interim.
Otherwise,
Heard Mr. You are Mr.
Yes, the
S. Jamal. Heard Mr.
half of it,
S. Jamal, the learned counsel appearing on behalf of Mr. H. Das. Also heard Mr. P. Botako, the learned additional PP appearing on behalf of, and Mr. D. Mehdi, the learned counsel appearing for the respondent number 2. It is submitted by Mr. Mehdi that they have already filed their wakalat claim, but needs some time to take the other instructions and to receive the relevant.
25. Yes.
However, it is submitted by Mr. Waterford that you have received a CD.
CD receipt, my lord.
CD has already been received. So what to do?
CD, my lord, Krishna is his statement is also available, my lord, in the CD. My lord,
Mehdi, what do you want prior the vacation? No urgency is there.
well, otherwise, my lord, I have gone through the CD. His statement, everything is available in the CD. Chief, well, before vacation, any date may be fixed. On that day, the matter can be disposed of.
You just take the instructions and try.
On 22nd or 23rd.
23rd.
Yes.
23rd. Is there be detained till next? Interim be continued till next.
26.
Very good. We need to. 26, yes. What is it? 26?
Receipt.
Okay. Yes. You have already appeared before the IO. Page number?
23. That is there. Can I read you? I'm not sure what you can read on page is right. Deny down. আমাৰ পৰিয়ালৰ দুখ উপস্থিত হৈ বিষয়টো লগতে পৰিয়ালৰ দুখীয় জনাই আজি পুৱা 10মান বজাত এগৰাকীমান ব্যক্তিৰ সৈতে কথাটো আবেদন কৰে লগতে জানিব দিয়ে যে যিগৰাকী বছৰ পূৰ্বৰ পৰাই সম্পৰ্ক আছে বুলি আবেদন কৰে
Otherwise, case diary received, my lord. His statement is available. At the last moment, my lord, he has cancelled the marriage, my lord. Marriage card issued. Even, my lord, pendant also, my lord. Yes, at the last moment, he has.
You think
Yes.
from that prospect, it is really.
Yes. Otherwise, incident is tragic, my lord.
Your civil suit is filed by the informant.
Same same legal fact.
So why money suit? Is there any transaction of money and all?
No, your lord. There's
As a compensation. So it is pending.
Pending. Before the civil the senior. In so far as your lordship, the offense of 360 concern your lord. There is no interest to the future. The experience of your lord. And when it comes to 380 your lordship, the FIR does not disclose any allegation of deception or fraudulent inducement or any false representation. This is just a breach of promise, if I may, your lord.
If you see by it is not a simple case of breach of promise because breach of promise will be there if you have some affair with the girl, promise was made subsequently due to some reason it could not be, so that can be considered a breach of promise. But as per the allegation in the FIR itself, it is seen that You had the relationship with that girl prior to 3 years
Yes.
prior, and then you got married. So very first day of inception of your
Yes.
thing, this discussion, marriage discussion, all where you have come to see the girl and all. At that very point of time, your mindset was just that I'm not going to marry her because you have a relationship. That this deception, inception is already there. That part we are not going. But obviously, civil suit is there
Yes.
for money suit, maybe for compensation and all. So that is there.
He appeared,
Otherwise, you reappear.
you have statement.
We don't think that there any requirement any custodial interrogation. Considering only this aspect, but we are not going to discuss any other merit of the case. There are merits.
Sure.
Anyway, your Mr.
NK Sharma.
আমি কিমান number 26 and
NK Sharma.
MK Sharma. Name is not here, na?
Your
Your name is not reflected.
my name is there in the wakalatnama, but it has not come up in this.
Oh, acha, you have already filed
Yes.
wakalatnama. You heard Mr. MK Sharma, the learned counsel for the petitioner, also happens to be voted for the learned additional PAPM on behalf of state respondent. Send application, section 7, connection, space. CD received, where's received. It is submitted by Mr. Sharma that the present accused petitioner is innocent. And from the plain reading of the FI itself, it is seen that there is no case, there is no ingredients to establish a case under section 316 subsection 2 or 318 subsection 4 of the BNS. Further, he submitted that after obtaining the order of interim pre-arrest bail, he already appeared before the IO and cooperated in the investigation of this case. He is still ready and willing to extend his cooperation if it is needed. Mr. Sharma further submitted that one civil case, that is the one money suit number 10/2026, is also been instituted by the complainant seeking compensation, which is pending before the learned civil judge senior division Tinsukia, wherein the present petitioner has also appearing and contested the case. Next part, Mr. Bortaku, the learned additional PP, submitted in district that there are inflammatory materials against the present accused petitioner in the case diary. However, he appeared before the IO and cooperated in the investigation after obtaining the order of interim pre-arrest. Considering this submission made by Learned Counsel for good sense, and also considering the materials in the case diary, this court is of opinion that custodial interrogation may not be required for the purpose of investigation. In view of this, the present the interim order granted to the interim injunction order granted to the present petitioner dated 17/3/2026 is hereby made absolute with same terms and conditions.
27 minute case diary not received. Petitioner is in interim.
You are an interim.
One.
CD not received. Issue reminder. Yes, what?
My lord, yes, is 17, 27,
27.
20.
20.
Yes.
27.
Apply.
20. Interim we continue.
Okay.
28 case diary received, my lord.
May I? Lordship, the other day, clarify, and we have expected the RS
27.
Lordship, technically, there is a dispute over trademark.
Dispute
And
over-
there is a civil suit pending. But while complainant informant that in the civil suit, one they would do and another honorable court case. Then they in the year 2000, I think Zahar civil dispute lordship, kindly have a look at the Azahar at page 37. Azahar dated 17/2000.
Yes.
I, Rahid Alam, holder of Orpan, attorney holder of Orpan jurisdiction, most respectfully submit this FIR for favor of your time, civil and military election. That one, Sri Amit Karmakar, proprietor of Orphan Biri Factory, Momin Biri, having legal right, authority and registration, but since 2023, case number 1, namely Ashley Momin Karmakar, along with other below-named person, have been dishonestly and fraudulently carrying on illegal business by manufacturing, supplying, and selling biri by falsely using the name of the Momin Biri Factory. So this is the main dispute. Momin Biri Factory. Lordship, kindly come to page 36. We have filed a civil suit before the completed.
Civil suit was filed by you.
Lordship. Momin Biri Factory, respondent Lordship, Orphan Biri Factory. We have also filed another civil suit, Lordship, that is also pending.
It is what? Commercial suit.
Commercial. Then you, Lordship, kindly come
So
to
what is your relief rate for in that commercial suit?
Lordship, kindly. Page 67.
Yes.
Lordship, a decree of permanent injunction prohibiting the defendant, his agent, designing or any other party acting on his behalf from committing trademark, passing off by using any identical or deceptively similar trademark to the plaintiff prior adopted and prior user trademark, further preventing the defendant from manufacturing and marketing that bear a trademark identical with the or deceptively similar to the plaintiff prior adopted and prior user trademark. A decree for delivery of or destruction under oath of all law sign and labels those are identical or deceptively similar to the plaintiff prior adopted trademark. In addition, the defendant has to pledge under penalty of law that he would never again use the trademark in question in conjunction with the plaintiff. A decree of permanent injunction restraining the defendant, whether himself or through his agent, residing or any other means, from passing off on the plaintiff existing prior adopted prior user trademark nomin. So it is his middle name from his he adopted. Lordship, now kindly come to page 109, suit filed by the proprietor of the Orphan Biri Factory. (109).
Yes.
This is the suit, Lordship. Hayat Enterprise is the brother of the complainant, and complainant is the attorney holder of the Orphan Biri Factory. So we are the
So
respondent,
Urban Beer Factory belongs to them only.
them. And Lordship, present complainant is the attorney of the Orphan Biri. So we are responded, Lordship, 109, kindly have a look. Momin Biri Factory. That suit they Udyo. Lordship, kindly have a look at page 124. Page 124. Suit they Fourth para, Lordship. Considering that there appears to be a defect and the jurisdiction also is under question, therefore the plaintiff is allowed to withdraw the instance with liberty to file afresh before the court of competent jury. Then he filed another suit, Lordship, after withdrawal of this one, page 125. Page 1 to next page, Lordship, 125. That has been stated by the Honorable Court. Lordship, kindly come to page 167. Operative portion of the order at last page, Lordship, 169 of bill. having considered the plaint of the various suit pending before the various court between the same parties, and nature of relief sought being similar, this suit having been filed at a later point of time, in terms of section 10 CPC, the suit is hereby stayed till disposal of the previously instituted. So he suit stayed. Then he, in the year 2026, Lordship, just to harass the present petitioner, lost the instant Tezahat. With the same issues, civil court is the competent court, Lordship, that it will be decided by the civil court. So we are in interim. I have appeared in other aspect, Lordship. Only one is involved in the business. Other petitioners falsely implicated. Others in no way involved. Two of the petitioners cultivated by profession, other one government service. So they are no way involved. Only one is involved and he has a valid license and issue over the trademark Momin Bidi. Momin Bidi is under dispute. That trademark under dispute. Civil court will decide. So criminal at this stage, Lordship, no case of Lordship fraudulent using the trademark. So my humble submission, petition already appeared.
So yes,
Yes.
case they received, my lord, they have appeared before the IO, their statement recorded, my lord. And now in their statement, they have stated that, my lord, their earlier, my lord, পেকেটবোৰ পাৰকাৰী ভাৱে অন্য ঠাইৰ পৰা ক্ৰয় কৰি আহি খুচুৰা বজাৰত বিক্ৰী কৰিছিলোঁ, and now they are not in any way related with any biddie business, my lord. And my lord, here one certificate of, my lord, central excise registration certificate is available regarding Orpon Biddie factory, and the proprietor of the Orpon Biddie factory is one Amit Kormokar. And my lord, the informant is one Rohit Alam here. My lord, he has stated that, my lord, on being power of attorney holder of Amit Kormokar, he has lost this affair against the present petitioner.
Presently, the beer factory of the petitioner is not existing now. They
Yes,
have
my lord.
presently the beer factory earlier, which was there with the petitioner side. I mean,
They have in their statement, they have stated that now they are not in. Earlier, they were involved in the business of selling, my lord, Momin Bidi. And now the statement of the witnesses stated that, my lord, yes, earlier মমিন নামৰ বিড়ি পেকেটটোৰ সৈতে অন্য ঠাইৰ পৰা ক্ৰয় কৰি লৈ আহি খুচুৰা বজাৰত বিক্ৰী কৰিছিল, আৰু পিছত তেওঁলোকে লাহে লাহে অধিক মুনাফা লাভৰ বাবে যিকোনো কেঁচা বিড়ি ক্ৰয় কৰি লৈ আনি উক্ত বিড়িসমূহ কোনো বৈধ লাইচেন্স নোহোৱাকৈ মমিন বিড়ি ফেক্টৰীৰ নাম আৰু ট্ৰেডমাৰ্ক অবৈধভাৱে ব্যৱহাৰ কৰি বিড়িসমূহ, so by using the name of Momin Bidi, my lord, they are involved in, my lord, making those.
but their beer factory was Momin, others one is Orpan.
Arpon, yes.
So dispute over only trademark when license. By license, Lordship, kindly have a look at Nectar 3, page 29. By license. At present, they are not running. Till disposal of the civil goods, they will not run the business. So Lordship, they are
Appeared statement recorded.
Heard Mr. Alamuju, the learned counsel petition. Also heard Mr. P. Botafu, the learned additional GP, appealing on. It's an application under section so and so, CD received, page the same. It is submitted by Mr. Moju that the present accused petitioners are innocent, and however, they, after obtaining the order of interim arrest bail, they have already appeared before the IO and cooperated with the investigation. The dispute is basically the using of a trademark, and on the basis of which they have already instituted a commercial suit which is pending for disposal. After institution of their suit, the informant side had instituted another suit, which was another suit, another civil suit, but subsequently it was withdrawn due to some technical reasons, and again lost another civil suit. However, the said civil suit was also stayed by the court under as barred under section 10 of the CPC. After stay of their suit filed by them, only in the year 2026, this FIR has been instituted against them with some false and concocted allegations. However, they are ready and willing to extend their cooperation in further investigation of this case if they are granted with the privilege of rearrest. Apart from that, the accused petitioner number 1 is involved, is associated with the BD factory, but the other petitioners are not at all involved in the alleged offense. They are simply a cultivator and engage in other profession. Next, Mr. Bordaku, the learned additional PP, submitted in this regard that from the materials available in the case diary, it is seen that it was the allegation against the present petition that they have using they have they used to purchase PD in a wholesale rate, and then it was they used to sell it in a retailing retailing shop, and for their benefit by using the trademark of Momin Bedi. Further, he submitted that as per the statement made by the present petitioners, they were earlier associated with the said Bedi factory, but at present they are not in connection with this Bedi manufacturing factory. However, all the petitioners have already appeared before the IO and their statements were recorded. Next, considering the submission made by Learning Council for the nature of the allegation and the also considering the pendency of the civil suit and the conduct of the accused petitioner, this court is of opinion that custodial interrogation may not be necessary for the purpose of investigation. Accordingly, the order of interim pre-arrest bail dated dated 19/3/2026 is hereby made absolute with same terms.
Of like.
Yes.
They were on interim. You were on interim.
Lordship, in the matter, we require some more time to file the CD. To
File
produce
the?
the CD.
File the?
Lordship, to produce the CD.
Yes, yes. They were granted with the interim on 25/3, I think. 5th of March. No, not 5th of March, 25th of March. Your interim was granted on 25th of March, and then the next date was fixed on 27/4. They could not produce the case diary. Then again on 12/5, you try to get the case diary within time.
I cannot hear you, Lordship.
No, you try to furnish the case diary in honor before the next date of listing.
Yes, Lordship.
Because 2/3 days have already done. Okay. Your MS? Hard MSG Deka, the learning council for the petitioner, also hard. Your MS?
P. Agarwal for Mr. H. Gupta.
P. Agarwal, appearing on behalf of Mr. H. Gupta for as a deputy SGI.
Lordship.
In Kuntu case.
For NF Railway, Lordship.
Yes. NF Railway, he is CGC deputy SGI. Who is he? I mean, what strength is Mr. Gupta is there?
Sorry, Lordship.
You are appearing for Mr. Gupta?
Yes, Lordship.
CGC who is
CGC, Lordship.
CGC.
NF Railway.
No, that is okay. Now she is saying that he is one Mr. Gupta.
Yes, Lordship. On behalf of Mr. Gupta.
এর নাম তো কি বলে? এর নাম কি? প্রিয়া গর্গ। প্রিয়া গর্গ appearing on behalf of Mr. H. Gupta, Reliance CGC, submitted that they need some more time to produce their case diary. Considering the submission made by learning counsel for both sides, the respondent is hereby directed to produce the CD on or before the next date of listing, positively on or before the next date of listing. List the matter accordingly on 15/7/15, 15/7 after the vacation. 15/7 interim be continued till next date of listing.
RT, my lord, case diary received, my lord. Petitioners are in interim, but their statement is not available in the.
No, we have appeared. I have appeared. Page 10 is the FIR. Page 10 is the FIR. Basically, litigation as part of FIR also, madam. Page 10, request for necessary legal action against dishonor of check by up power engineering work private. Allegation is regarding for the dishonor of check. Page 10, the heading of the FIR subject with the dishonor of check. If the institution check to his suppliers, madam, allegedly it got dishonored. Then they made a complaint to the circle officer. Circle officer has solved this case, stating that the heading itself got it not a real matter.
It seems.
It's another they have a separate mother remedy mother file case under the topic knows mother. And I
Heading is regarding dishonor of sex, but my lord, this FIR from the.
Contents are bit, yes, that's what also I'm
yes,
going to ask.
the contents are
But my lord, but because my lord,
suppliers the check got dishonor, then he went then
not only sex, my lord, otherwise they are actually, my lord, workers of working under the present petitioners, my lord. The present petitioners are the, my lord, employee of UP Powers
yes.
Renewable Energy Works Private Limited, my lord, who are involved in, my lord, construction of a of a solar project, my lord. Solar project. Thereafter, my lord, negotiation was held between the present two petitioners, my lord. While after issuing those checks, my lord, were dishonored, my lord, between the, my lord, these accused persons and the other victimized persons in the office of the circle officer. And in that understanding, my lord, they have also, the present petitioner also has given one undertaking. That undertaking is available in the CD, that they will pay the salary of
Now it seems that obviously in the subject is it seems that is a matter of check or dishonor of check, but the rest part there are some other allegations anyway. Yeah, as per your instruction, your petitions have already been appeared, but we need the
yes, I will have to
thing
get the
guideline.
updated.
Okay. Petitioner, only one petitioner
One
here.
petitioner. He's also an employee of that mother UP Power.
UP Power.
Not even disposition of also mother because
Huge amount of salary, my lord,
they
money.
can find this because it relates to dishonor of check. Nothing.
These are poor workers, my lord, involved in, my lord,
Even though mother
engaged
says-
by them
yes,
for
mother,
working
the
on.
only giving an undertaking out of pressure to the circle officer mother that they will do their duty mother. That is their but if you are under the pressure mother, but check was issued, it got because actually mother these works are published by another company mother. So that company is not the other use, that's why he is unable to pay those. I have categorically stated in my
Whatever, let them make an inquiry then in that regard.
Yes.
Heard Mr. S.M. Abdullah P, the learning counsel for the petitioner, and also heard Mr. P. Botapu, the learning additional PP, appearing on behalf of state. It is submitted by Mr. Botapu that the case diary has been received, but the statement of the petitioner is not available in the case diary. Whether this bail order is there
Bail order, my lord.
in the CD,
No, my lord, bail order is also not available.
and the bail order, interim bail order is also not available in the case diary. However, it is submitted by Mr. Abdullah that as per his instruction, The petitioner has already appeared before the IO and his statement is also recorded. In view of this, later updated case that we call for with a direction to the police to furnish the updated case diary along with the statement of the petitioner, if already recorded. And further, the petitioner is also hereby directed to appear before the IO within 7 days and to record his statement if it is not recorded, if it is not yet recorded. CDB return accordingly, calling for an updated one. It will be after vacation. We'll do. I think.
Yes,
Otherwise,
on
get problem.
21/7, man.
We'll do 21/7.
After vacation.
Yes, after vacation.
Right.
21/7. Interim be continued till next day.
Can it be, 10 days, not 7 days.
10 days. Okay. 10 days. Okay. Well,
I'm obliged.
And I will return the CD, man.
yes, it's written.
Obliged.
Yes. What is the office note?
My
Acha, you have already appeared.
appeared already.
And yeah, you have received the case diary.
My CD receipt.
Okay, then yes.
FIR with fact change for change.
10.
May I keep for the keep specify that last one where data is taken here that it should take advantage of access me along with the other family members. That above the person all daughter as the book each house after that the act then in front of him, then the that part of my daughter is up. While the husband
Submitted that it is not at all a fit case to grant anticipatory bail to the present petitioner. Post of next paragraph. Hearing this submission made by Lani Council for Process, I have also perused the case diary. It reveals that the victim girl had made a categorical statement before the learned magistrate at the time of recording her statement under section 183 BNSS, wherein she described as to how on 12/3/2026 she was molested by the present petitioner, taking the advantage of her age. Her statement also remained found consistent in the and her statement under section 180 BNS is also found consistent. Post of it is further seen that from the statement made by the witnesses as well as from the materials in the case diary, that though the incident took place on 12/3/2026, out of fear, she did not report the matter before her parents, and only on 23/2026, when it was inquired, as she was she used to remain silent, and also frightened when she saw the accused. Then only she revealed the entire incident, and thereafter, as all the villagers and the family members were busy for Eid festival, a festival of Eid, they approached subsequently the police station with an FIR with a delay of some days. Thus, though the delay is not explained in the FIR, but the circumstances under which the FIR is lost the FIR is lost is FIR is lost. No. However, last line to last line. Yeah. Buza নাই তার আগৰ লাইনটো কম লাইন টু ব্ৰেক petition, and thus there is justifiable reasoning explanation found in the materials in the case diary. Next paragraph. So considering the entire materials in the uh, case diary and the gravity of the nature and gravity of the offense, this court is of opinion that it is not at all a fit case to extend the privilege of pre-arrest bail to the present petition, and accordingly this same stands rejected. Your petition stands rejected. Oh.
Madam, here CD not disseminate, there is interim, madam.
CD not received.
Not disseminate.
CD not received. Issue remainder. Yes, Sharma, when it can be.
My lord. After vacation,
16.
14th month.
He is saying 16. 16.6. 16.7, sorry. 16.7, interim be continued till next date of listing. Okay.
43.
Yes.
My lord, CD received, my lord, along with the medical report, my lord. Along with medical report.
CD received along with the medical.
Medical.
Yes. Yes. Yes, you can read.
Next page. Positive, on positive.
On positive.
And 180 years category negative regarding the part that with the part by the
Yeah, the other incident, what the altercation, threatening part, whatever it is,
let's say one witness
it was taken in the marketplace.
my lord.
The allegation of the other allegation, that is the rape and all, these are not in the marketplace.
One
Okay.
witness, one witness is there, my lord. I have taken my lord. In his presence, the present petitioner speaking the murder of the in the bazaar area. Witness, one of the
That bazaar incident is not disputed. It's okay. Bazaar incident was there. One altercation, no, he was also there. Anyway, yes.
I will also feel of it. Yes. It's a habitual matter. Earlier cases. That's why
Lordship, keeping in mind the criminal antecedents of the petitioner, he might not be granted anticipatory bail at this stage. Also, as submitted by the petitioner, the age of the victim is not more than 18 years. She is below 18 years, Lordship, as per the date of birth. There are clear implications in 183, Your Lordship.
Mr. Khan, as per the report now, she is also pregnant now. That is the main issue. Now she is pregnant. This they give the positive test. Gave the positive test of pregnancy. So at present she is pregnant. No, initially when the FIR was lodged, it was not there. Obviously it was not there, but at the time of medical examination, it has come out. At the time of lodging the FIR, most probably they were also not aware of it, was not there, admitted. That is it. And we heard Mr. M. Khan, Ilani heard Mr. P. Sharma, Ilani additional PP, appearing on the state respondent, and Ms. T. Parashar, Ilani amicus, appearing for the respondent number 2. This is an application under section so and so in connection with so and so CD received penalty. It is submitted by Mr. Khan that representing his petitioner is innocent and he has not committed any such offense as alleged in the act. However, it is a fact that there was love affair between the victim and the present petitioner. And when the mother of the victim came to know about their relationship, she charged the accused, and there was an altercation in the Bajar area. And on the said Raj only, the FIR has been instituted with some false and concocted allegations. That apart, the petitioner, the victim was 18 years of age at the relevant time of incident, though the case is registered under the POCSO. Petitioner is, however, ready and willing to extend his cooperation in further investigation of this case if he is granted with some intervention. Next paragraph. Mr. Sharma, the learned litigant PP, raised objection and submitted that from the statement made by the victim, it is seen that the accused petitioner used to have sexual intercourse with her forcibly on the false pretext of marriage when she was a minor girl. In regards to the age of the victim, the school certificate as well as the one birth certificate is also seized by police, and the apart from the Aadhaar card and Aadhaar card. As per uh, the 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 school authority has also issued a certificate whereby stating that the birth certificate which was seized by police is found to be a genuine one. As per the birth certificate, the victim was admittedly below 18 years of age at the relevant time of incident. Mr. Sharma further submitted that from her medical report also it is seen that she was sexually exploited, and at present, as per the medical report, she also gave the positive test of pregnancy. In that context, Mr. Khan submitted that there is no such mention about her pregnancy in the FIR, and it was the FIR was lost only due to grudge after an altercation between the informant as well and the accused. Next para, MS Parasha, the learned amicus appearing for the respondent number 2, submitted that the age of the victim was admittedly below 18 years at the relevant time of incident, and and from the allegation made against the present petitioner, the bail may not be considered at this stage, and that the party accused also have the criminal antecedent wherein the other cases already been registered against him. Mr. Sharma. Next para, Mr. Sharma, the learned additional PP also submitted that as per the note of the IO and from the matrix in the case diary, it is seen that there are presently two cases are pending against the present petitioner with similar kind of offense. One has already been charge sheeted, and other is still pending for still pending for the investigation. Still at the investigation stage. Next part. Hearing the submission made by learned decides, I have also used the case record and the statement made by the victim as well as her medical. So it is the plea of the petitioner that there was no physical relationship with the victim, though there was a love relationship between them, but the medical evidence suggests that there was a physical relationship between her and the petitioner, and that apart her pregnancy test also gave and that apart there was a positive test for pregnancy is also found during her examination. However, from the statement made in the FIR, it is seen that there was no allegation that the girl became pregnant due to the physical relationship with the accused, but it can be held that at the relevant time of filing the FIR, the family members or the victim may not be aware about her pregnancy. So, considering the nature and gravity of the offense and basically the statement made by the victim, this court is of opinion that it is to extend the privilege of pre-arrest bail to the present petitioner at this stage, and hence the same stands rejected. Your petition stands rejected.
Okay, fine.
Yes, what is 35?
And 35, we have received the case diary, my lord. The statement of the my lord present.
What your instruction says, as per your instruction.
Appear on
You have already appeared. You are Mr. A. Huda.
But here it is stated my lord, he has appeared, but his statement is not available.
But he appeared.
Appeared.
Heard Mr. A. Huda, the learning counsel for the petition. Also heard Mr. B. Sharma, the learning additional PP. It is submitted by Mr. Sharma that CD received, and it also reveals from the note of the IO that the petitioner had appeared before the IO after obtaining the order of interim pre-arrest bail, but his statement is not available in the case diary. However, it is submitted by Mr. Huda that as per his instructions, the petitioner had already appeared and his statement is also recorded by the IO. In view of this, Let a updated case diary be called for from the IO by returning the CD with a further direction to furnish an updated case diary along with a statement of the statement of the petitioner if already recorded. The matter accordingly after at least when it can be 15, 16, 17, 16, 16, 7 video interim be continued till next. You also make an inquiry, just appear before the police station. I have not passed any direction so in that regard. But if not recorded, ask them to record. Otherwise, it will be remain pending. Objection to Palin.
16-7.
16, 7. Right. Objection to Palin. So, someone had filed objection, na? Objection filed by you, na? It has come. Yes. At page? Particular at page? Wait. Yes.
Okay.
My lord, one development is there, my lord. The case is searched.
Oh.
It is searched. Number
Then to
7, dated my lord 13/5. 13/5,
CS number
67. 67 stroke 2026, dated 13/5. Thereof.
case to you have to approach the learned track.
Well, that is clear in the my lord FIR because my lord he was under threat, my. He was under threat.
in that case, we have to go to the merit also. Otherwise, how can you? You know that that kind of statement was there. She made that statement. No. How can you say that she made a statement earlier, a different statement, subsequently a different statement? No. You're saying that that statement is differ from the statement subsequent. That's why, is there any reason? Now she left her house by her own because of quarrel. Then subsequently she got recovered on 5-2 and then handed over to so and so. Why thereafter? Why they will pressurize the victim? But without his any involvement. I mean, if suppose it is case is registered under which section? It is registered under which section? Six box. Then
Yes, but my lord, in her 183 statement, she described everything.
see
And
what I'm
said,
saying, Mr. Bora. Suppose if you think that interview should be there, we have to discuss the entire merit of the case. One, and after discussion, after hearing the additional PP as well as the other side respondent, it may not be a case for interim also. Say suppose I'm saying.
Yes,
So in that case, if entire merit is discussed, it may otherwise may disturb you also. I'm thought on that way. Because before us now CD is also available and we know, and he has the recent development that his case there is already been such. So I think because most probably they have also filed their objection, they may have something to say. Though as per you there was a negotiation was going on for 1 month, obviously 1 month delay is quite a big delay. But for them also they may have some sort of explanation that due to, that's why may not discuss, I think, at present. I heard Mr. D.P. Bora, the learned counsel for the petitioner, and also heard Mr. E. Sharma, the learned additional PP appearing on behalf of State 10%, Mr. K.K. Medi, the counsel appearing. You are with amicus or counsel appointed? Counsel appearing for the respondent number 2. The case diary was already received, and Mr. Medi, the learned counsel for the respondent, has also filed his written objection. But at the time of hearing of this case, it is submitted by Mr. Sharma, the learned additional PP. That case has already been charge sheeted by CS number 67/2026, dated 13/5/2026. In view of this, this court is of opinion that the petitioner may approach the appropriate court, that is the trial court, with an appropriate application for regular bail, which may be considered in accordance with the above observation. The present AB stands. Okay, you just appear. Sit.
Dispose of my
Dispose. Time. Mr. Porter will hear it too. Will hear it too. Your matter is, next matter is yours, I think, 37. You have received the case diary here? No, but I'm not feeling so well. Yes, we have received the case diary. We'll do one thing then. If someone represent you at 2 p.m., if you're not available at 2 p.m., we'll keep it at the by time being. Timing will keep it at the time. We'll call for the 37. Page 10. So car was basically not in your name, but it was in the name of your father. Within 1 month.
It's the contents of the affair has been come to reveals that there is some business transaction between the petitioner and the informant, and petitioner has induced a complainant and cheating the informant by compelling him to pay rupees 4,50,000 in on the pretext of purchasing a vehicle, selling a vehicle to the informant. So after the courtship, after taking the money, he has failed to give the vehicle as well as the documents of the vehicle. So he did not pay a hit to return back the money also. So there is a monetary transaction is going on in the courtship. To that regard, some materials are there, and I have also gone through the 183 statement of the victim, the informant, along with his two brothers, two other persons. They have categorically implicated that this person fraudulently taken the money. So that much is.
As per you, the how much the amount is 2 lakhs.
In Lordship, they have taken 4.50, 4.5.
5.
Yes. 5 lakhs. They have given the statement 183.
So whether it was within the knowledge of the informant that the vehicle stands in the name of, not in the name of the petitioner, but in the name of his father.
Later on, they have come to know.
At the time of executing the warrant,
yes,
it was not within their knowledge.
yes,
Achha.
yes. That they have later on came to know. Lordship may go through the 183 statement of the victim.
So what are the case? This stage, is there any requirement of custodial interrogation?
There was only that part, cheating part is there, and inducement in this part.
Heard Mr. S.K. Poddar, learned constitution, heard MSSH Borati, learned additional PP, appearing on the an application, so and so in connection. See the receipt. Is submitted by Mr. Poddar that obtaining the order of pre-arrest, interim pre-arrest bail dated 13/5/2026. They have already appealed and cooperated in the investigation of this case. At the time of taking Jimma by his father also, he visited to the police station along with his father and along with his father. He further submitted that the false delegation has been lodged against the present petitioner with the allegation that he wanted to sell the vehicle of his father uh, at an amount of rupees 4 lakhs 50. So it is the admitted fact that the vehicle was purchased only 1 year prior to the alleged agreement, and within 1 year the vehicle cannot be cannot even sold in the price which is more than half of the actual original, or I mean the original value of the vehicle. However, he is still ready and willing to extend his cooperation in further investigation of this case if he is granted with some interim protection, if he is granted with the privilege of pre-arrest. MS Borat learned traditional PP submitted in this way that at the time of from the materials there are some incriminating materials found against the present petitioner, and at the time of agreement was not within the knowledge of the informant that the vehicle stands in the name of the father of the petitioner, and suppressing the fact there was an agreement executed between the parties wherein 4 lakhs 50,000 was alleged to have been 4 lakhs 50,000 was given by the informant for the purchase of the vehicle. However, she submitted that after obtaining the order of interim pre-arrest bail, he already appeared before the IO and cooperated in the investigation. Considering this submission, made by Lani I have also filled the case diary, considering the materials available in the case diary. It was available in the case diary is found that custodial interrogation may not be required for the purpose of investigation. In view of this, the order of interim pre-arrest bail dated 13/05/2026 thereby made absolute with same terms and conditions. Here also we have received the case diary.
Yes, ma'am.
Consignment of jute. Number plate. Number plate. So though Jimma order was there in your favor, but till late Jim. But that Jimma application was filed by through one Nurul Huda. So you are saying, but the Jimma petition was filed by him, or acha, without
By him.
appearing before the police station.
Yes.
Acha.
This custody or this custody interrogation is required or not for the purpose of then that part only my life. If you not would like to go to the FIR, this FIR is page number 26. If I may read, they don't need this work because as whether the from there for double for for W30D or more Kolkataর এখন ডেলিভারি দেওয়ার কর্মকর করা তো কাস্টমার বইটা কোন ধরনের যোগাযোগ থাকে আর ডেলিভার করা নহয় পৰৱৰ্তী সময়ত আমি কৰিলেও কোনো সন্ধান লাভ কৰিব নোৱাৰিব এই সন্দৰ্ভত বিৰুদ্ধে এখন এফআইআৰ কৰা হৈছে পিছত আমি জানিব পাৰো ডেট ইজ ওৱান ডিফাৰেণ্ট এফআইআৰ পিছত আমি জানিব পাৰো যে এক কন্ট্ৰাক্ট এই WC50 পুৰী জিলাৰ গৰিপুৰ আৰু এলেকাত জামত কৰা সন্দেহজনক কথা সেই গাড়ীখন চলাই গাড়ীৰ ভিতৰৰ পৰা মূল চলান আৰু মোৰ দ্বাৰাই জাৰি কৰা গৰিপুৰ আৰু আৰু গাড়ীখন অবৈধ কাৰ্যকলাপত জড়িত আছিল এই গাড়ীখনে বিভিন্ন ব্যৱহাৰ কৰি আছে আৰু it is that basically this was already seized by the covered and the second consignment was also good consignment. Now that the only thing is that he is willing to appear and cooperate with the institution, but since he hails from West Bengal, the IO has never even bothered to go there and record his statement, nor he has bothered to issue any notice. The notice, my lord, in the
Notice issue.
see, notice to my lord, the driver, that is at page number 33 to Jamilul Islam, my lord, on issue.
To the present petitioner also, notice issued. দিছে এইটো আমার নোটত লেখা আছে এইটো
33 was issued.
therefore I tried to send another notice.
He is connected with the day-to-day operation of the Jamilul Islam. He is from Assam.
Let him appear with some stringent condition because he hails from West Bengal. এইটো notice. Yes, 16/5 notice was served. Notice was sent to him. Sent.
But as per your story, in the consignment, in your truck, the consignment was booked
No.
from where? No.
My story is that my truck was not connected with all those consignments because those consignments had a different number, registered. Even if it is connected, my lord, even if those registered numbers are connected to my truck also, then also, my lord, I have nothing to do with the day-to-day operation of this truck because the day-to-day operation is being looked after by one Jamilul Islam, to whom the notice was issued. He is from Assam, my lord.
Heard Mr. Esther, the learned from the petition. And also heard Mr. P. Sharma, learned petition PP, appearing on behalf of the state. It's an application. CD receipt. Submitted by Mr. Das that the present petition is no way connected with the alleged offence. Neither any consignment was booked in his truck, nor he ever received, nor he ever, nor anyone had booked any consignment for delivery of the same to West Bengal, Kolkata, West Bengal. Therefore, his day-to-day transactions were also looking after by one Jamilul Islam who hails from Assam. And even if there is any such, so and so, thus he is not at all connected with the alleged offense. However, however, he applied for. However, the truck was seized by police during the investigation of this case, and when the petitioner, as a owner of the registered owner of the said truck, had applied for the timber petition, where only the IO raised the issue that the owner of the truck never approached the police station, and whose statement is also necessary necessary for in connection with this case, as well as to make to furnish a report to that regard. Petitioner, however, is ready and willing to appear before the investigating officer, as you have not received the 35(3), you received.
But it is sent, well.
Sent.
Yes,
Till
it
then
is
he
in
has
the
not received
case
any 35(3) notice to appear before the investigating officer. But he is still ready and willing to extend his cooperation and also to record his statement by appearing before the IO if some interim protection is provided to him. Next para, Mr. Sharma, the learned additional PP, submitted in this regard that the truck of the informant was, petitioner was seized in connection with this case, and as per the materials available in the case diary, the notice under 35(3) was already sent to the petitioner. By which date? 17/5. Notice was sent on 17/5.
My lord, date. One.
You have said 17.5, I think. I
Yes, ma'am.
noted down, but
On my lord, 16.5.
16, on 16.5 2026. Accordingly, it is submitted by Mr. Sharma that an opportunity may be given to the petitioner for recording statement. Considering the entire circumstances of this case as well as the materials available in the case diary, this court is of opinion that some interim protection may be provided to the petitioner to appear before the IO and to cooperate in the investigation in view of this. Okay, you will be provided with some interim protection, appear before the IO and state when it can be listed.
With some condition, my lord.
No, definitely conditions.
After vacation,
So you need 7 days or 10 days to appear before IO.
from West Bengal back. 10 days back.
10 days, you're giving you 10 days. List after 15/7 will do, Sharma.
My lord,
15/7.
20.
15/7, 1.
Where please you go.
Yes.
This is case, my lord. Whatever, my lord, the file was lost by the mother of the victim, my lord.
Mother. Mother of the
Mother of the victim.
Mother of the victim, my
Acha,
lord.
acha, acha.
He committed suicide, my lord. Lordship will find the FIR at base 13, my lord. In a rented house at Gauhati. My lord, the petitioner before your lordship are the father-in-law and mother-in-law. So, lordship has found
Yes.
the FIR, my lord. They were residing, the husband and the wife was residing in a rented house at Gauhati, my lord. So far, the petitioner before your lordship are concerned, they were residing at Obhayapuri, Bongaigaon. Subsequently, after closing of this affair, case has been registered and the petitioner accused number 1, that is the husband, my lord, Chiranjit Poddar Rajdeep, he was arrested by the. But during the course of the investigation, my lord, they put the petitioner on bail application before this honorable. But at that stage, my lord, during the course of finding some material, my lord, the petition was rejected. Thereafter, police never searched for us. And subsequently, the search sheet had been laid, my lord, under section 306 and section 4 of the Dowry Provision Act. Now, lordship will find the search sheet at page 20 and 21. Next 3, madam. Page 21, lordship will find established against the accused persons, namely Chiranjit Poddar, Rajdeep, Nando Poddar, and Ribon Poddar. Under section 306 of the IPC, read with section 4 of the Dowry Prohibition Act. Nando Poddar and Ribon Poddar are absconding from the date of occurrence. Therefore, I intend to submit the search sheet of the arrest. Please the search sheet. Now, mother, the petitioners have received someone from the court of Learned Chief Division registered number. Kamrup. Lordship will find the copy of the summons. Annexure 4, my lord, page 49. Initially, the date was fixed on 28/5/2026, my lord. But on that day, due to the occasion of the Eid, my lord, the court remained closed, my lord. Subsequently, the next day has been fixed on 8/7. 8/7. 49.
Next date is?
My apprehension is that, my lord.
Next date is?
Next date is on 8/7. The petitioners are old age person, my lord. Respectively, their ages are 63 years and 56 years. Our only apprehension is that, my lord, after receipt of the summons, if we appear before the court, my lord, of the Chief Division Magistrate, where the offence is being triable by the Court of Session, my lord, we might be taken into custody. So, my lord, some protection, my lord, we are ready to participate in the trial, my lord, and regularly appear, my lord. Some protection, my lord, would be direction may be on our appeal. Consider our pay. It is the limit of care.
Lordship, from the contents of the FIR, it is revealed that there is a serious offense against a victim girl, Lordship, who happens to be the daughter-in-law of the present petitioner's, Lordship. She has been persecuted both physically and mentally, harassed by the petitioners along with the other accused, Lordship. And Lordship, thereafter, Lordship, during investigation, police has registered a case against the petitioners, and after having found sufficient materials, Lordship, a search sheet has been filed. That is on Lordship 25/01/2024, Lordship. Thereafter, Lordship, on 2/4/2026, on the basis of the materials available on record, cognizance has been taken under Section 306 of IPC, paired with Section 4 of the Dowry Prohibition Act against the petitioner, Lordship. And accordingly, someone has been issued in order to assure their presence before the court, Lordship. And date was posted on 28/05/2026, Lordship. Since, Lordship, during the whole investigation period, they were found to be at large. They are remain absconder, Lordship, in the date of occurrence. And if a prima facie case is made out against the petitioner, and the entire case is at present pending at the stage of appearance, Lordship. So I'm vehemently object the petition, bail petition at this moment, because there are sufficient materials against the petitioner. Because from the suicide note itself, the name has been reflected that the other petitioner, along with these two petitioners, has inflicted both physical and mental torture upon the victim.
Now, he is taking play that these two petitioners were residing at Ovaipuri, and the husband and wife, that is the victim,
Lordship.
and the accused number one, Muslim, they were
Lordship.
residing at 20th House.
Lordship. But
So,
the charge sheet
is there
says,
any-
Lordship, kindly come to page 20. Brief of the search sheet is that on 7/12/2022, on receipt an Azahar filed by informant so-and-so, where it was inscribed that on so-and-so at about 9:30 p.m., a daughter, namely so-and-so, was found hanging in the rented room of her son-in-law, so-and-so. And in the suicide note found nearby, the deceased has mentioned that due physical and mental tortures from the husband, so-and-so, and his parents, Nanda Padar and Jivan Padar, the present petitioners before Lordship, the victim committed suicide. And thereafter, Lordship, O.C. Jalukbari PS registered a case on under Section 304B, 306 IPC and entrusted so-and-so to investigate the case. And during the course of investigation, IO has visited the place of occurrence, examined the witnesses, seizures are made, accused persons apprehended and forwarded, whole inquest by executive magistrate so-and-so, and handwriting samples were sent for FSL, which has given a positive test that the handwriting that is in the suicide note, that resemblance with the handwriting of the victim, Lordship. And that report also proved, Lordship. I'm entrusted to complete the investigation procedure. The final postmortem report, the doctor has opined it. I am of the opinion that death was due to asphyxia as a result of antemortem hanging, which is suicidal in nature. During the course of investigation, the prima facie is well established against the accused persons, namely Siranjit Pattar, the son of the petitioners, and Nanda Pattar and Jivan Pattar, the present petitioners. And these two persons are absconding from the date of occurrence. Therefore, I'm inclined to submit CS against the arrested accused person, so-and-so, so-and-so, so-and-so. Because from the
So, where
suicide.
is the order? Have you annexed the order whereby your earlier bail petition was rejected?
Yes, that is there, Lordship. That is on page 17 onwards. Paragraph 6, page 18 will be relevant, Lordship. May I read, Lordship? A close scrutiny of the case diary as well as the suicide note clearly reveals that the petitioners have been incriminated. I have considered the gravity of the offense. There appears to be no justified ground to extend the privilege of anticipatory bail to the petitioner at this stage of investigation.
Lordship, my respectful submission is that over the minutes of the case, I am not submitting anything right now. So the premature incident because the copies are yet to be punished to us. Go to the only my submission will be that we are ready to face the trial. If there is anything against us during the course of the trial, we will definitely face the music. There is no question of evading the trial. Only contention is that we were reciting at Ovaipuri. The incident has taken place in a rented house at Gauhati. Our names have been proper. The FIR is concerned. Our name has been implicated in the FIR. Only on that count, at that stage, during the course of investigation, our prayer is. Now we are ready to face the trial,
we are ready to appear. Someone has been issued, my lord. Only apprehension is that, my lord, the offence being triable by the court of session, my lord. If we appear before the Senate Court of Chief Judicial Magistrate, my lord, we might be put behind the, we might be taken into custody. Only on that count. It is not that we are saying that we are innocent and all, my lord, at this stage. Because this is a premature stage. We
Lordship,
are ready to face the trial.
Lordship's charges are yet to be framed. So if they have any reverse, they can file a petition at the time of framing of charges. At this stage, I'm objecting.
Are Mr. Peters and necessity for the be a premium be proceed. Application section students. Care copy of has already been received. Separate receipt. Expert submitted by Mr. Das, the counsel for the petition that these two petitioners are no way in the list of they are the parents-in-law of the victim who resides at Abhayapuri and the victim of the deceased as well as her husband, that is the accused number 1, used to reside in a rented premises at Gauhati. Thus, they are not at all connected with any arrest of as described. However, coming to know about the registration of the case, they have already earlier approached before this court with a prayer for accepted bail that has been rejected by this court, and thereafter the charges has been filed showing them that the accused persons have already received notice from the court and they are still ready and willing to contest the case by appearing before the learned trial court if some kind of hearing is provided. The petition. If further is submitted that case being decision tribal in nature, wherein the charge sheet is filed against all the accused persons under section 306 IPC, railway section 3 of the 4 of the dowry prohibition. After rejection of the earlier bail petition, the present bail application has been filed seeking bail for the present petition. However, they are still ready and willing to appear before the learned trial court below on each and every day to be filled by the court. Further submitted that after a rejection of the bail order, earlier bail application, the police never searched for them, and hence they were also not in a position to know the stage of the case as well as to cooperate the IO. Mr. Das accordingly submitted that this is a big case where the privilege of interim period bill can be provided to both the petitions. Post. Next, MS Borat and additional this objection and submitted that the case is of serious in nature, wherein the charge sheet has been laid against the petitioners under section 306 IPC, railway section 4 of the Dowry Prohibition Act. This is submitted that on the materials available in the case diary also seen that the petition accused number 1 is not only the accused petitioner number 1 is involved in the alleged offense, but these two petitioners are also equally involved in the alleged offense. And in the suicide note also the victim uttered the name of these two petitioners. She accordingly raised her objection, submitted that it's not a case to grant prayer for intercessory bail at this. However, they can appear before the learned trial court below with a regular bail application, which will be considered in accordance. Next, Hearing the submission made by Lani Constable, I have also filled the case record and the case diary received. It is a fact that the in earlier occasion also these two petitioners appeared to this court with a prayer for anticipatory bail. Previous bail, which was rejected by its order dated 3/4/2026 in connection with AB oblique AB 20, AB 68 oblique 2020. We further submitted that the case is charge sheeted under the session tribe. The cases of submitted are cases of session tribe, and hence the even if the petitioners approach the learned trial court below, there is very less chance of providing them with bail, and for which this state petition is filed, praying for free respect for both the petitions. Next, MS Bora, the learned additional PP raised objection and submitted that there are sufficient incriminating materials in the present accused petition, and as per the suicide note also, these two petitioners were also involved in the alleged offense, though they claim to be the resident of Amaipuri. They never cooperate with the IO, and for which only these two petitioners have to be shown as an accordingly, she submitted that submission Google our submission আসলে আপনি তাক মিলাই দিব তেতিয়া মানে এটা 18 কোডৰ এটা অৰ্ডাৰ আছিল ন 3/4 এটা অৰ্ডাৰ আছিল মেনশ্যন কৰা হ'ল লাষ্ট এটা এলাইনমেন্ট কিবা কাৰণে ৰিপিট হৈ 2023 আছে তাৰপিছত তেতিয়া কিনে from the submission made by Learned Counsel petition, it is seen that after the rejection of their earlier anticipatory bail prayer, they were never searched by police during investigation. So considering during investigation, and hence it is a case that the petitioners had approached this court with a prayer for anticipatory bail, but subsequently they did not cooperate with the investigation. However, considering the entire circumstances of this case and the nature of the offense, this court is of opinion that some interim protection may be provided to the present petitioner till the petitioners appears before the learned committal court with a regular bail application. In view of this, the petitioners are hereby granted with the privilege of pre-arrest bail. I was and so elaborate on the list of seeking of that till the case committed committed before the learned trial court of the learned session. Okay, you are granted with some protection till you appear before the till the committal till the case is committed before the committee.
Compliance.
But there will be some direction, other direction, avoid by all the direction.
Organized.
Okay, keyhole. I think it has a yes, in item number 6,
No, sure.
for respondent number 2, there are names of 2 advocates are there, one B. Chakraborty and
Yes,
T. Islam.
both are absent today.
I have not seen them in the court today also.
It's a maintenance case, lordship, the reference is required.
Yes, yes. Is there any development regarding any talk, anything?
Doctor, after talking about order on March, but we have paid another 4,000 deposit now. What that area amount is?
Area amount is spent.
My proposal is that I it is not will get 10% per month.
15,000 per month and another 10.
He's paying another 10,000. That will be comfortable for him. Otherwise,
I mean, towards the area payment. That's why I'm asking there. If other side is ready, then we can pass the order in that manner. Maybe your approach is for your prayer is for 10,000, and there may be a bit higher, but at an amount can be settled. But today they are not. I don't know why I have not seen them. The councils, 2 councils are there. On the last occasion, it was a submission from their side that the area amount is 4,15,000 and towards that you have not paid anything. But till that order was passed on 2005. You have not paid anything to that regard now, till now.
Now only 40,000 paid, apart from the monthly negative.
40,000 was paid in which date?
After 23rd of March.
But not after the last order.
He's suffering from, I don't know what to say, the right hand is.
And what had happened, in fact, on the last occasion, most probably you were absent and no representation has been made on the last occasion.
Yes.
They were present, but you were not there. So we could have heard the matter in presence of both the councils or the parties. But that was not there. Anyway, I heard Mr. K.K. Handy, the learning counsel for the petitioner applicant. None appears on call for the respondent. However, it is submitted by Mr. Handy that till that he is paying the monthly maintenance allowance and towards the area amount and towards the and rupees 40,000 has already been paid towards the area amount. However, the petitioner is ready to settle the matter for area amount and he has the capability of paying rupees 10,000 per month towards the area maintenance amount. But In absence of the other side, the appropriate order, on the other side, the order cannot be passed today. Let the matter be accordingly listed when it can be listed. After 1 month, when it can be. Today, kiman tarik hoyse? Sura pura hulok bera diyo. 17/7.
The last order in NPV was file. This is not on record. So we called on
As per
record
the last order.
because this
You want to file in one additional
no,
affidavit.
that isn't filed. It's already filed copy of
Just now,
file.
yesterday. You have received the copy.
Lordship.
It is not
Not
taken
in
the
the
record.
record. But not it. It come after order. Maintenance is they have been terminated from job. He was working in a co-terminus job. That project is also that have problem. That will be ready for
Through an additional affidavit, you have brought all this.
the subsequent to filing.
Acha. Mr. R.J. Das, সেখানে the petition. Also, heard your MS?
Edas.
ADAS, সেখানে also for the response. It is subject to Mr. Das. They have already filed the additional affidavit, and a copy is also served to the other side in person to order dated 1905. However, it is seen that that additional affidavit is not back with the record. In view of in view of this, the registry is hereby directed to take the additional affidavit which has been filed by the petitioner on or before the next date of listing. List the matter accordingly. It will be obviously after vacation because we don't have any 207.
Lordship.
If you
Eight, state is a formal or
state is required by law.
Achari?
State.
No,
Yes, yes.
state is a part.
Yes, yes.
And you are for the response number 2.
The person who has filed that.
Acha, okay.
Now your lordship is kind to page 22 the FIR.
Oh,
Page 25.
Yes.
Respected madam, I trust this letter finds you in good health. We would like to bring it to your notice that two practitioners of dentistry practicing in various locations of Gauhati district mentioned below have been giving treatments to the patient. We have encountered various cases along with their prescription which does not mention their qualification or registration required to practice dentistry in the country. Kindly find the evidence attached pertaining to the practice in this application. Therefore, we request to verify the above mentioned document of this practitioner and do the needful as it is suspected that this dental practitioner do not have the required documents and license to practice dentistry. Now, your lordship, below, my lord. Additionally, it has also been found that two registered dentists have enrolled themselves along with their practice, whose names along with the address are mentioned below. Number 1, Dr. Rama V. Thousand PTS, so my lord. Next line, my lord. Ohibul Haq, registered number 1026 PM, suspected and to be verified from the Assam State Dental Hospital. This was the FIR, my lord, claiming that we are quiet.
What the line means? Dr. Ranu B. Thanson, PDS, registered number so and so.
Registered
In
Assam,
bracket, they registered under the Assam State Dental Council.
And
Has enrolled to,
dentist.
that means what? Has enrolled to dentist Mohibul Haq?
Actually, my lord, Mohibul Haq is working under that dentist, my lord, Rana BDS, Rana B1000, my lord, in his clinic.
Oh, Mohibul Haq is working under
Working under Rana B, that is, my lord, from the record.
Oh, acha, acha, Rana B. Thompson. Acha.
The petitioner
So,
picture-
as per, I mean, it is wanted to show in the FIR that he has no such enrollment.
Yes.
Without any enrollment.
petitioner before your lordship is Mohibul Haq.
Hmm.
My lord, my first submission is that, my lord, I never claimed to be a dentist. Now, my lord, after this, the FIR was registered, my lord, I was arrested, my lord, on 1/4/24 that your lordship will find at page 24, the forwarding. Page 24, my lord. Counts of arrest, my lord, number 4, my lord. Various prescription and 2 numbers of bill have been seized from the possession of the arrested accused Mohammed Mahibul Haq, and prescription prescribed to the patient have been recovered from the informant. Next paragraph, my lord, during the course of investigation, it is learned that the minimum qualification is required to practice dentistry in Assam, India and Assam, is Bachelor of Dental Surgery BDS, and awarded by a recognized university, but the arrest accused person doesn't have this qualification, as it was found after serving the notice under section 91 PRC from OC Sir Hodai PS. So it is clearly found that he is not eligible and found to be fake dentist. Treated many people by practicing this, it might causes injury to the patient. So they made an inquiry whether I am a doctor or not. So in the instant case, my lord, charge sheet was laid, my lord. Now, my lord, the lordship turns to page 19 for a while.
Page?
Page 19, my lord, 19. And my lord, this is, my lord, Sardar Patel Postgraduate Institute of Dental and Medical Science, Lucknow. I am a diploma in dental mechanics. This was certificate, my lord, Mohibul Haq, the son of so and so. The next page, my lord, page 20.
So you are a diploma of dental.
Dental mechanics. Diploma in dental. The next page, your lordship will see, my lord.
Yes.
Page 20, my lord. This is a registration certificate of dental mechanics. Lordship will kindly note that, my lord, certificate number 1026, my lord, dated 13/9/21, my lord. This is to certify that the person named below have been registered as a dental mechanic, Uttar Pradesh, under the provision of the Dentist Act 1940. So after passing out, my lord, the course, my lord, I have been registered as a under the dental council, my lord, as a dental mechanic. Now, my lord, the police, my lord, the investigating agency in the course of the investigation, my lord, seized, my lord, one steel, one, my lord, letterhead. That I have added your lordship will find at page 42 for a one. Last page, my lord. Page 40. Last.
Yes.
Lordship will see, my lord. See, my lord. Dr. Rano V. Thousand, my lord. He is a doctor, my lord. He has written BTS, my lord, registered number so and so. Below, my lord, Mohibul Haq, my lord, registered number 1026, DM, my lord, dental mechanic, my lord, SPPGIDMS, that relates to the college from which I passed, my lord. That is, my lord, Sardar Patel Postgraduate Institute of Dental and Medical Science, Lucknow. So, my lord, I never cheated, my lord. Well, I have not cheated, my lord, Dr. Mohibul Haq. Only Mohibul Haq, my lord, registered number showing so DM means, my lord, dental mechanic. And, my lord, these prosthodontics and prosthodontics and crown and bridge, my lord. Prosthodontics, my lord, it means, my lord, replacing a missing or damaged teeth. And my lord, every dentist have a mechanic, my lord, who makes the, my lord, artificial teeth, my lord, all those. So in the instant case, my lord, I never claimed to be a dentist. From the letterhead which has been sealed by the police, my lord, it, my lord, reflects, my lord, Mohibul Haq, registered number so and so DM, my lord. And the above name, my lord, Rano V. Thousand, my lord, he is a doctor, my lord, he was not arrested. Thanks. So therefore, proceeding in this case, my lord, my lord, I never claimed to be a doctor, my lord. I'm simple at dental mechanic. Now, my lord, I am educated. Now the question arises, my lord, whether my degree from that institution is valid or not. In this regard, my lord, I have found one additional affidavit, so that your lordship will find that page is additional. And your lordship will see, my lord, the principal so and so. It's a Dental Council of India, my lord, later, my lord. Subject inspection report of the council inspector Dr. S.S. so and so for recognition of dental mechanic course at Sardar Patel Postgraduate Institute of Dental and Mechanical Science, Lucknow, conducted on 10/1/2011. I am directed to state that the general body of the DCI, that is being held on so and so, considers the inspection report of the council inspector Dr. So and so for recognition of the dental mechanic course at Sardar Patel so and so, Lucknow, my lord, carried out on 10/1/2011, and after discussion and deliberate accepted the following recommendation of the EC 31/2011. The council may recognize the dental mechanic course with intent of 15 seats in respect of dental mechanic students of Sardar Patel Institute of Dental Science, Lucknow, is granted on or after 10/1/2011. And my lord, I passed out, my lord, in the year, my lord, 13/9/21. The registration certificate is my lord, 13/9/2021 at the state. This is my case. I was never claimed to be a doctor, my lord. I was all along a mechanic, my lord, and I was working under the Dr. Rano Thousand, my lord, Rano V. Thousand, my lord, in Lanka Dental Care Laboratory.
এইখন সব বস্তু নাই এইখনতো ৰেকৰ্ডত নাই
That is my case. I never claimed to be a doctor. I all along was the name appeared in the letterhead. But letterhead also doesn't say whether I am a
My lord, I will regarding other materials, I will point out, my lord, regarding this, my lord, document that was now, my lord, annexed along with the additional affidavit, because at that point of time that was not produced before the, my lord, during investigation. Now this document came to, my lord, was annexed as a part of the additional affidavit. Regarding that document, I would like to, my lord, that is, my lord, I have also found one document here, my lord, of Assam Dental Council. Regarding that, I would like to point out the relevant portion of that, that is issued by the Assam Dental Council at the time of during investigation, was issued by the Register Assam State Dental Council on 23/2024. My lord, may I read, my lord, some of the, I am just only reading the vital portions, my lord. That letter was addressed to the, my lord, Superintendent of Police, my lord, Huzai. The following names of the suspected dental practitioners have been mentioned in their complaint. So and so all these names, and one dentist Mohibul Haq, registration number so and so, my lord. 1026
Yes.
DM. So, my lord, the dentist Mohibul Haq. And now, my lord, the above mentioned person, my lord, this is important, my lord. The above mentioned person are not registered under Part A and Part B of the Dentist Act. Neither they are eligible to register their qualification, my lord, under any state dental council, because these courses are not recognized by the Dental Council of India. So they are not eligible to do any kind of dental practice, and necessary action should be taken at the earliest from your end. That is the, my lord, that document is issued by the Register, Assam State Dental Council on 20. So, my lord, this is now conflicting, my lord, that document of the Assam State Dental Council and this document now annexed with the, my lord, additional affidavit, my lord. So both are contradictory, my lord. Your lordship may. And now regarding
This,
other materials
this,
against the present accused, my lord.
This document which was subsequently brought on the record, that is the document number 46.
Yes, my
As
lord.
per you, it was not produced before the IO.
Yeah, because the genuineness of these documents at that point of time, if produced, then Assam Dental, my lord, document issued by the Register, Assam State Dental Council during investigation on 23 to 30, part of the record, my lord. It was sub record. Oh. And regarding other materials, my lord, the doctor, Mr. Thausen, my lord, who is under whom, my lord, he is the present petitioner is practicing. His statement is also available, my lord, and the present accused person also statement also available. And from his chamber, my lord, some of the, my lord, seal and those, my lord, one of the prescriptions also seized by the police, my lord. And as per his statement, and my lord, accused is he is practice not only, my lord, he is in fact practicing as a dental surgeon, my lord, not as a, my lord, dental mechanics, my lord. From their statement of the witnesses, it revealed that without having any, my lord, qualification for practicing as a dental surgeon, my lord. And regarding a detailed list of some other doctors also there, my lord, but against some of them they have produced genuine certificate and they are genuinely practicing. Against those doctors, my lord, no search sheet not filed. Against other person, including the present petitioners, who were, my lord, also, my lord, doing their practice without having any valid qualification for practicing as a dental surgeon or as a dentist, my lord. Against them, finding material search sheet submitted by the IOMI.
The page 19 and 20, my lord, which I have annexed to my petition, that were, my lord, seized by the police, my lord, during investigation. Whether the investigating agency made a verification of these two documents, because these two documents were seized by the police, my lord, and in fact, they should have investigated the matter and write a letter to the concerned authority whether it's genuine or not. And in fact, not doing so, they have asked the Assam Dental Council to verify it. It was the duty of the
Whether that is there, is diploma in dental mechanics course.
Yes.
One certificate is produced by an annexure 3 as a, I mean, page number 19. So in that regard, whether those this certificate is genuine or not, into that regard, was there any
Regarding that, my lord, I have not found that police went to that particular, my lord, University of Uttar Pradesh and, my lord, verifying regarding the genuineness of those documents. Regarding that aspect, I have not found anything, my lord. But from the report of the, my lord, this register, my lord, this letter issued by the Register Assam Dental Council, he has specifically mentioned that, my lord, the language is that, my lord, neither they are eligible to register their qualifications. My lord. They are in fact not eligible to register their qualifications. In fact, dental mechanics, that is the qualification of the present petitioner. Their qualification is also, my lord, not entitled to be registered under Assam State Medical Council or Indian Medical Council for doing any kind of dental practice. My lord. So the, my lord, qualification of dental mechanics itself is a, my lord, doubtful degree for practicing as a, my lord, dentist under, my lord, for any kind of dental practice, my lord, registration under Assam State Dental Council or, my lord, Indian Dental Council is, my lord, necessary. My lord.
Yes, do what?
Uh,
So case is still under investigation.
no, my lord, search sheet submitted. Finding materials against these accused persons, search sheet submitted.
Yes.
So, my lord, last submission that as because search sheet, my lord, search no appear. Let them place, my lord, all these materials at the time of filing of the search. Otherwise, my lord, the genuineness of the present document, which is annexed, it itself, my lord, for conflicting with the document issued by the registrar of the Assam Dental. Which one is not, my lord, their qualification itself is, my lord, for any kind of practice of them.
Lordship, I also rely on the submission that is made by my learned friend. Also, Lordship, they do not have the requisite qualification. And the registration is also a very big doubtful question also, Lordship. So as they have claimed that they are guilty, they are innocent, so Lordship, as also charge sheet has been submitted, so Lordship, then they can face the trial, Lordship. Then.
In last month, although those documents were used by the police, the police never investigated from where it had happened. They only asked the Assam Dental Council whether it is genuine or not. Have investigated that part.
Standard of done for the petition also. So we bought the done additional PP appearing on behalf of respondent. Your MSP does
Lordship M. Bhuya.
M start MS M Bhuya, the done council appearing for the petition number 2. Oh, sorry, respondent number 2. This is an application section 528 of BN for posting of the impugned charge sheet number 201 of 2024 dated 27/08/2024 arising out of Hojai PS case number 88 of 2024 dated 21/03/2024 under section 419, 468, 471, and 34 IPC, and also to cause the subsequent criminal proceeding in PRC case number 1114 that 1117 of 2024 pending before the court of learned CGM Hojai. Next right is submitted by Mr. That in the present case, it is the basic allegation of the prosecution that the present petitioner, along with some other, is practicing as a dentist without having the requisite qualification or degree, without requisite qualification and degree. The during the course of the investigation, the present petitioner got arrested in connection with this case, and he was forwarded before the learned sitting. He further submitted that from the ground of arrest, also it is seen that that various prescriptions and 2 numbers of steel has been seized from the possession of the arrested accused, the present petitioner, and prescription prescribed to the patient has been recovered from the informant side. That apart, it is also alleged that during investigation, it is learned that minimum qualification required to practice as a dentist is BTS from any recognized university. But after arrest of the accused person, it has come to the knowledge while serving notice under section 91 CRPC that there is no eligible degree a degree possessed by the petitioner, and he is a fake dentist and thus cheated many people practicing as a dental surgeon, which also causes injuries to the number of patients. But the present petitioner is not a dentist, and he never practiced as a dental surgeon. Rather, he is a dental mechanic and had obtained his degree from
Hartan Patel, postgraduate Institute of Dental and Medical Science, Dhaka. He's 9.
obtained his degree from Sardar Patel Postgraduate Institute of Dental and Medical Sciences, Lucknow, and where from he got the certificate of diploma in dental mechanics course. Mechanics course, and he never practiced or never issued any prescription, etc., showing him as a dental surgeon or dentist. From the letter pad, which has been seized during the investigation, it is seen that his name has been written in the letter pad as Mohibul simply as Mohibul Haq, with his registration number as DM, who is also a mechanic of prostato prosthodontics, 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 and Crown and Bridge, who was working under Dr. Reno V. Thousand, THAOSEN, Thousand, who has the degree of BDS and was practicing as a dental surgeon, wherein the present petitioner was simply working as a dental mechanic under him. in that letterhead also, his name was not written as a Dr. Mohibul Haq, and thus he never represented himself as a dentist or a person with PTSD. Further, Mr. Dr. submitted that that the Dental Council of India had gave a certificate to the principal of Sardar Patel Institute of Dental and Medical Sciences by as a and the said inspection report. It is stated that that the dental mechanic course at Sardar Patel Postgraduate Institute of Dental and Medical Science, Lucknow, was recommended by the council, and the council also recognized the dental mechanic course with intake of 15 seats in respect of dental mechanic students of Sardar Patel Institute of Dental Science, Lucknow. Thus, there was also an received letter from Deputy Secretary of the Dental Council of India that such kind of course of dental mechanic was offered and recognized by this institute, wherefrom the petitioner got his diploma in dental mechanic course. He further submitted that the petitioner never cheated any person, or he never practiced as a dental surgeon. He simply was working under Dr. Thausan so and so as a dental mechanic, wherein his registration number was also mentioned. But without going into those aspects of the case, accused petitioner got arrested in connection with this case, and case has also been charge sheeted against the present petitioner, and for which a criminal petition is to be instituted for quashing of the FIR, the charge sheet, as well as the criminal proceeding pending before the learned trial court. He further submitted that it is a quick case whereby the entire proceeding as well as the FIR and the charge sheet can be quashed by complying the provision under section inherent power under section 528 of the ASS. Next para, Mr. Botaku Delaney additional PP raised objection and submitted that he was practicing as a dental surgeon, and during investigation it has come to the knowledge that he also gave prescriptions to the different various persons during while he was practicing and showing himself to be the person of to be the registered dentist registered practice of registered practitioner of on dentistry. He further submitted that during inquiry it has also come to the knowledge that there was no valid degree. He obtained no such valid degree from any recognized university and there was no such course offered. You have submitted, no such course was offered, or what?
Yes, my lord.
I mean, dental mechanics course is not there. As per
Yes,
you.
your lordship, that is there in the record, my lord. I have checked mark some state council letter attached by the register to this patent number. I have checked mark. That letter is there in the record. And my lord, statement of Dr. R.V. Thousand, under whom the present petitioner is, my lord, practicing, his statement is also there available.
His statement is also here. So that letter was from
By the register of the Assam Dental Council, my lord. Oh, State Dental Dental
State.
State Council to the Superintendent of Police to that first portion of the second page of
that his name is, the present petitioner's name is
Mohibul. His name is P, madam. In that letter, my
later. I'm still searching. That letter was from superintendent to the
SP, my lord, Hudai, from the register, my lord, Assam.
SP Hojai by State Council.
The 11th portion, my lord, I have marked from the first page, my lord.
Oh.
From the beginning. That is the second page, my lord.
Mm-mm. They submitted that the Assam State Dental Council had also wrote a letter to the SP Hojai, stating that on inquiry, they have found that no such certificate was issued to the present petitioner. And these courses are also not recognized by the Dental Council of India and Council of India, and hence they are not eligible to do any kind of dental practice, and necessary action should be taken at the earliest. Full stop. Full stop. Thousands is he is also here.
Every 1,000 statement is also have that part of the name of the last page. In fact, earlier not awarded the
Further, the further the doc further Dr. Thausen has also stated in his a- in his statement that the present petitioner was working under him uh, and was practicing at the relevant time of incident. But at that point of time, he was it was not known to him that he does not have any degree, and on the basis of some fake certificate, he was practicing under him. Next para. Further, Mr. Portapur also submitted that the documents which has been annexed along with the additional affidavit, that is the uh, regarding the genuineness of the degree of the present petitioner, was also not before the investigating officer, and that was not produced at the time of investigation. To make any further investigation to that regard, which has been annexed along with the petition, shown to be issued by Dental Council of India, stating that the dental mechanic course was offered, and it was recommended by Sardar Patel Institute of Dental Science Law. Further, it is submitted by Mr. Portapur that after the and thorough inquiry and after a thorough investigation of this case, the case has been charge sheeted against the present petitioner, and hence charge sheeted against the petitioner, finding prima facie materials, finding prima facie materials against him, and hence at this stage there may not be any they enhance only on the basis of none, and hence it is not at all a fit case to pass any order of quashing by invoking power under section 528 of PNSS. More so, the case is at the very initial stage of the proceeding and charge is not yet framed, and hence the petitioner will get ample opportunity to pray for his discharge at the time of charge hearing. Mr. Portapur accordingly raised remand objection and submitted that the petition may be dismissed. Next para, MS Das Kuluni, P Das, MSK Das Kuluni, P Das now, MS, no, you're Bhuya. You're Bhuya or Das? Sorry, I'm very sorry.
Lordship M. Bhuya.
Bhuya.
Yes.
MS M. Bhuya, the learned counsel appearing for the informant respond number 2, so submitted in this regard that you're saying the 19 and 20, those the annexures.
Lordship.
Now you have submitted 19 and 20 about annexure, I mean, page number. No, you're submitting sorry, the page number 19 about in regards to page number 19 and 20, na?
No, Lordship. I'm relying on my submission of the charge sheet, where the charge sheet has been mentioned that during the course of investigation, they do not have that certificate. Also, without the certificate, they have been treating the patient. I'm relying on that submission, Lordship. So if they're pleading to be not guilty and innocent, then let them face the trial, then, Lordship. That is my humble submission.
Submitted that after the investigation, prima facie materials found against his petition, and that he is practicing as a dentist without having any registered degree However, they will get the chance at the time of evidence, as well as at the time of charge hearing to pray for his teachers, but at this initial stage of investigation, at this initial stage, the petition for quashing may not be entertained and accordingly prayed for dismissal. Yes. So, I have recorded your submission. I'll pass you over today itself.
And also,
Additional affidavit given up.
Oh, no, tomorrow. Wait a minute. Sound people, mati ruka. It order hold. Aji dispose. Oh,
In the same party, husband and wife. Or I can say it's the 2016 revision against domestic violence case. And recent one, 2025 is the revision against maintenance. Now, why five file or two cases?
is there any talk of negotiation, etc., going on? No, not.
Can say
You are for the
husband.
husband in both the matters. Yes, anything?
Ma'am, actually, what happened in this case, Your Honor?
No, I'm not going to hear the matter. That's why I'm just asking whether there is any probability. Because what was the amount of this maintenance amount was?
Earlier, the case, one maintenance of monthly 5,000
Yes.
and a lump sum amount of rupees 1,50,000.
That is for towards the cost or something.
No, ma'am. It was against compensation.
Acha,
That
compensation.
is
Sorry.
also under challenge. It was state milot in the year 2016.
It is it's still stayed.
That part 1,50,000.
Acha, 1,50,000.
Monthly, I have been paying regularly. And in the year 2020, the wife respondent again filed a petition under 125 year. And there also another amount of 5,000 total 10,000 per month.
You are
That is-
paying now.
Now the second part is state by this honorable court in the first revision petition item number 9.
That part is state.
Yeah. I have been paying earlier amount of 5,000 till now, madam.
But during that period, there was no such enhancement was there. No, any kind of enhancement is there.
Oh,
Enhancement is not there. So at present, you are paying 5,000 per month.
and
One has already been
and
stayed.
an amount of I think 2,000 for earlier my lord used. Total 7,000 I think.
Acha.
Earlier dues were some, so I think another 2,000 has been paid by the other.
So now she is the only lady or any children
No.
is there?
Only. She is staying with her brother.
Just staying with her.
Lordship, actually, what happened in this case, Lordship? Both the petitioner and the respondent was married on in the year 2000, Your Honor. Lordship. Thereafter, Lordship, after our solemnization of their marriages, she has been suffering various mental atrocities and physical torture. Actual fact is this, Lordship. On Lordship,
No,
that-
whatever. Now she's not with her. I'm
no,
not
no,
going.
Lordship, I am just telling the original facts, Lordship.
No, we are not
What I mean-
going to hear the matter. I'm just asking whether there is any probability.
Lordship, he has already filed a revision petition, Lordship. Basic thing is this, Lordship, that this revision petition,
What he do? Husband, what he
Teacher.
huh?
Teacher.
he's a headmaster,
He is a
Lordship.
teacher.
Headmaster, Lordship.
Is a government employee.
Government employee, headmaster of LP school.
Oh, headmaster too, definitely it will be.
Lordship, or he did not regularly pay the earlier maintenance rupees.
But there is a area amount is also there.
Yes, Lordship. Lordship,
That area amount was at the time of initial my lord order because the order was passed.
still, Lordship, minimum 40 to 50,000 has been pending as an area amount. The amount which is fixed in the DV case. I have checked the check even in the trial court, Lordship. Actually, what happened in this case, Lordship? The petitioner was maintaining illicit and illegal relations with a lady, namely Jinti Das. Jinti Das, Lordship. On Lordship, 26/1/2014, Lordship, the said Jinti Das had eloped with the present petitioner. For which, Lordship, her husband, namely Sondeswaran Das, has lost the missing report before the Kamalpur police station, which has been annexed in my affidavit in reply. At page number, Lordship, 102.
If my lord is hearing the matter.
No, I'm not hearing it. Muslim আনলো। এই দুইটা তো মুসলিম না। Sondeswaran Das is not Jinti Das.
Lordship,
The parties are seems to be.
Lordship,
মানে-
Sondeswaran Das is the second wife, husband, Lordship. She is a Assamese lady, and the present petitioner is the Muslim person. Without taking any divorce, Lordship, she had, that particular lady had eloped with the present petitioner, for which the respondent was forced to left her matrimonial house on 17/2/2014. Finding no alternative, Lordship, she had to take shelter in her brother's house. Lordship, despite
Well then.
under such compelling
no, but,
situation, Lordship, she
my
filed a DV
intention
case.
My intention was only to ask you whether there is any probability. If there is no such, I think there is no such probability of any negotiation.
Yes, Lordship.
Because suppose he is paying
And Lordship,
5,000 per month. So if it can be suppose
My lord.
some to
In
some.
fact, my lord, in the morning, I also asked him about that possibility, whether 5,000 has been paid. Now 10,000 is to pay. Is there possibility
Yes,
7 or 8?
in between.
In mind. He can take it.
You can take instructions because
Lordship,
obviously we are not denying, we are
Lordship,
paying, and he is also paying to you
In
because
the morning,
you are considered to be his wife. No
Lordship,
issue on that. That's why I thought that if there is a possibility, that was only asking. I was
Lordship, actually, my learned friend had already filed a revision petition before the additional district judge, Lordship. And Honorable District Judge has already upheld the decision. And kindly
we are
peruse the
not
Lordship.
on that.
Huh?
They have challenged the order. They have come before
Yes,
the
Lordship.
court as a revision.
Yes, Lord.
Thereafter, and then
This is the second revision, which is
second
not
revision.
maintainable in the F law.
So you can. I'm just saying, is there any way out? Maintainability definitely will get the chance because it is in a garb of this. It is a second revision petition.
Yes, Lordship.
That can be understood. So you can argue on that, no issue. Like, we are not taking the hearing matter today. That's what I'm just asking, whether any probability of any negotiation. That much only. If there is not at all there, then definitely case will go. No issue. These 2 weeks is not possible. It will be definitely come after vacation only. Either maybe 16 or 17.
Right.
Obviously on July because after vacation.
17?
17.
Lordship, if 16, Lordship, if possible.
Is there any problem with you on 17?
Lordship, if possible, 20, Lordship.
20 of July. It will be okay for you also, not?
Yes, 20.
20. Is that? Yeah.
20 of July. 20.
Hearing this.
9 and 10, দুইটা বেলে বেলে কে লিখবো, কারণ টিটার হয়ে যায় না, নাম কেটা একেবারে একে কাউন্সিল আছে। 9 কারণে সেম কাউন্সিল, 10 কারণেও সেম কাউন্সিল, খালি 20 নহলে একেলগে মাৰিব পাৰি, একেলগে মাৰিব পাৰি। Add a request.
কিমান দিলে?
Okay, both the matters we are listing as per your very on 27. 20. In the month of July, yes, 20.
Interim may be continuing in both cases.
Yes, interim will continue till next set of listing in both cases.
Okay.
Okay.
Deeply obliged, Lordship.
Yes. You are for the petitioner. This is what is it?
My lord, here last occasion, my lord,
NBW was issued, it was recall, my lord. The last occasion, my lord. Thereafter, lordship was pleased to call for trial for record, my lord. Here I have gone through the
NBW is already recalled.
recall, my lord. Here I have gone through the record, my lord. My lord, here wrong record came here, my lord.
Oh,
That is here, Borkhola PS 1/26. That available record is here, my lord. But actually, it should be Lonka 119, no?
no, if it is record is there, it is pending before some court.
My lord.
How?
Second,
Otherwise, it a special case, POXO, na?
my lord, Lordship may call for the corrected, my lord, record, my lord, trial for record.
As per your information, where it is pending?
You know, it's pending for the additional distinction that
हो जाए.
within POCSO case number 115 of the 2020.
Just repeat.
Arising out of
Special
the-
POXO 11
115/2020.
23 20
23, 2020.
before additional session judge हो जाए. And your case connection is wrong.
My lord, here it was trial for record received Borkhola PS 1/26. That is different, my lord. It is food safety.
But this particular case is in connection with which case? PS case is there the PS?
My lord, Lonka PS, my lord.
Lonka
Lonka, my lord.
Lonka PS
119/23.
119 of
119/2020. Arising out of that.
heard Mr. T. Daskar, Dilanet. Also heard Mr. B. Sharma, Dilanet. Appearing on behalf of the respondent. And MST Parashar, Dilanet Amicus, appearing for the respondent. It is submitted by Mr. Sharma that the scan copy of the TCI has already been received, but it is received, but wrong record has already been, no, sorry. It is submitted a wrong scan copy of the TCI has been received, which is in connection with Borkhola PS
1/26.
Borkhola PS case number 1/2026.
That is under section 61(2). That is
No,
here, my lord.
Borkhola and the
Safety and
the
standard.
correct case and the required cases, Lonka PS case number 119/2023, which is pending before the learned additional session judge, which is and numbered as special POCSO case number 115/2023. Pending before additional session judge को जाए लिखते ना. In view of this, the registry is hereby directed to call for the correct scan copy of the TTR from the constable. Registry will do the needful. Yes, it will do.
অলপ পিছত দিয়ক, অলপমান পিছত লাষ্ট
22 of July.
জুলাই মাইল
Yes, 40 already. Oh, this is I, na? For condonation. For condonation.
Yes.
3019 days.
You filed revision petition against the judgment of the.
No, whatever the condonation is 3019 days.
I have objection.
Objection means you have already filed your objection.
Objection file as 2820 days because he has some copy me like that.
Oh, yes, on the last occasion.
Last occasion, Honorable Court has recorded that submission, Lordship.
In earlier order.
Yes, it is already.
Yes.
But whatever you have already filed your objection.
Oh, yes, it's same thing. Days only 3019 days.
3000.
Abnormal delay, Lordship. Should not condone, Lordship.
Now, I have some work. I do not have any position to hear the matter on IA. So, it will be on another date. You are Mr. M.M. Rahman. Mr. M.M. Rahman, the Learned Counsel for the petition. So, M.S. R.B. Bora, the Legal Aid Counsel, appearing for the respondent.
I would like to submit
No, I'm not going to hear him. We're not hearing the matter. When so, no, I don't have any. So and so, and it is submitted by MS Bora that she has already filed her written objection to that record. Let the matter be accordingly listed in orders column on. Yeah, it will be okay. This month only we are going to list it. Otherwise, we are listing it on July. But for your considering your prayer, we are listing it on 25th of this month. 25/6. 6/6 this month. Yes. Deeply. Oh yes, Mr. Brook, what to do now? What is now your what is the present status? Just still.
Of May, they did not appear before the trial.
Did not
Did not
appear.
Did not appear. As such, this is the order. Now the state of the case is that none of the accused has appeared before the trial court. Now, out of the 5 accused, against 2 of the accused, their bail was cancelled by the Honorable. Thereafter, now we are here to one is already absconded.
So apart from the other grounds, they are not abiding the bail conditions also.
Yes, yes. So my only prayer is that they cancel. They violated the condition itself that they shall regularly appear before the trial court.
It is okay. That will come that violation of condition. Otherwise, what you have filed your petition for cancellation? Was there any ground? Now it is in additional ground. They have violated. It's
Yes.
okay. Earlier to that,
This figure Lordship, yes, I have written few of the grounds Lordship, but Lordship, it had to be adjudicated by both the parties. Uh, I think it's an application but also is required to be done. Now that is the reason now only I am pressing for cancellation based on the sole ground that their condition stood by it. Their bail condition stood
where is the bail order initially?
at page number 65. And page number 76 is the condition. First and foremost, defendant shall appear before the court of further special judge and its what can every date to be fixed by the
Okay, I can understand. This is the one of the condition which has already been violated. It shows from the record also. Now, otherwise, there was some ground.
There
You are
was
saying that there
some
to be
grounds based on
adjudication, yes. But do one thing, Mr. Brook. We are accepting your additional ground that he is not abiding the rules. And that about if we tried your level based, we tried through the that process also we are trying to, and every time it return unserved or whatever. So now, so there is for us, how can you serve a notice? Because they are now pleading away from the even they're not appearing before the trial court bill. So that is the issue, one of the issue. The other 2 orders do you have whereby they have cancelled the bill by the Honorable Supreme Court? There they have contested the case before.
Yes, Lord. They had contested. And it was heard and cancelled by the Honorable. I had submitted
Here only?
yes.
Okay. Yeah. So which- this- what is one for you? Then we'll do one thing. We'll record your submission only this one, and we'll hear the matter from your submission also. You make some submission on that regard also. Why initially you filed your petition for cancellation of bail, and in context of the order passed by the Supreme Court also, you make some submission. We'll record it. But today I'm not in a position to hear the matter, so we'll list you matter only this month until the end of the week. That is on 24th of this month. Okay, on that 24th will be convenient for you. Otherwise, we are not listing much matter on 24 and 25. But seeing that the petition is pending since 25 when cancellation, so need to pass an order. So I thought that maybe better to fix it on 20. Will that day we'll fix another day. In between, is there any date for the Learned Court below? No.
Next August.
August. You have to list the matter. I could list the matter on the part, Mr. K. Proof and counsel for the applicant, and let the matter be listed accordingly on 24/6/2000. We're listing it on 20. What is the IA for?
No, I is for getting of stay.
Stay.
Stay. It's a stay. Of state that no course.
Pardon? No.
22. The maintenance states to the TV case. So the applicant is still there. I'm still the legally vetted wife. No divorce has taken place.
No, in DV case, you want a proceeding to be stayed.
We have filed for stay here, and the same has been stayed.
Vacating of state.
Oh, for vacating of stay.
Vacating of state.
Oh,
If
earlier
case has
on,
already been stayed here.
on their prayer, other side of prayer of the other side,
Yes.
there was an order of stay.
There is
Yes,
order of state.
Oh, in DV case,
DV case has been stayed here.
not be in DV case. Anyway, so this is the IA for vacation. Acha. To criminal petition. You have annexed the, okay, you have annexed the order of stay here in the criminal I itself.
That's right.
In which page? And against the order of
Your Lordship, Mr. J. Kalita, due to having some personal difficulties, he has to leave the court early. So the matter may be fixed for hearing on day after tomorrow, on Friday.
day after tomorrow.
Day after tomorrow. For hearing, Lordship.
Why on hearing? Otherwise, it is ready for hearing also.
Yes, Lordship.
Oh, then yes, it can be.
The hardship is, they have filed it.
Yes.
That is my page only regarding the idea, the idea is the postdoc. The other matter, they can take any case really for the case.
No, but if case is ready, then it can be heard. No issue on that.
This is happening wrong. Lordship, this is issue with
Yes, Lordship.
very long ending.
Both the matters may be taken on Friday, Your Lordship.
Your Lordship, the matter can be taken after vacation also. I don't mind that. I'm only concerned about the lady is without a room and without maintenance. And
Lordship, regarding maintenance, the felon has been paying 15,000 per month. Lordship.
that it is their state.
I have also some statements also that the petitioner has been paying online through online mode.
They have made a statement, I'm not paying since 2015.
Criminal petition is filed by you. Filed by them.
Item number
then নামটা উল্লেখ করা
42 is filed by us. Criminal petition 217 is filed by us.
217. And what is criminal petition 235?
That is for stay of the proceedings. And TV.
No, then what is IA for?
IA they have filed.
Fine. I have filed my I in 213. Your Lordship,
You have filed IA in connection with 217.
213.
And originally 217 is filed by them.
Filed by.
And 235 is filed by you.
This is another petition. It is connected with 125 proceedings. Kindly go.
So as the parties are same, it is
That's why
connected.
it's clubbed together. Otherwise, reading the
44, 43 বলে কি order 42 or 43 করবো বলে 42 টা মানে আপনার যে কলিটা petitioner আৰু Mr. H.S. Kalsi আছে for response number 2 in item number 42 for criminal petition. Your good name?
Yes, Kathak Lordship.
Yes?
Kathak.
And the
In Lordship, in item number 42, there's in interim order.
S appear probability on behalf of Mr. J. Kalita. 42 sub 42. S Kathak appearing on behalf of Mr. J. Kalita. Are equally Mr. H.S. Kalsi. For the response number. Adjournment, the Mr. Kathak accordingly paid for an adjournment stating that Mr. J. Kalita already left the court premises due to some urgent purpose. Prayer allowed. List the matter accordingly. When yes, we are listing it again in order column. Okay. As per you, it should be in order column.
Hearing.
after petition, after hearing the petition, let's see
Further from the submission made by Learning Council for Courts, it is seen that the matter is also ready for hearing, and hence, let the 21 July will do.
Lordship, interim may be continued.
Pardon?
Interim may be continued.
No, 21 July will do. 21 July. In which case you have interim?
217, Lordship.
217. 21 দিব. Interim will continue till next date of listing. Or itu রাখো criminal petition 235 যে আছে এটুত Mr. Khalsi আছে for the petitioner and Mr. J. Kalita, Mr. K. Kathak appearing on behalf of Mr. J. Kalita. বাকি করে লিখন লাগে list the matter 21/7 in hearing court. Registry is ever directed to list the matter in hearing court. Okay.
I
45. So here also confusion. IA criminal is filed by whom?
The respondent.
Filed by? Acha, respondent side.
No,
And
remember-
basically you filed your revision.
Revision, my lord. Your lordship may remember that revision petition which was coming up, the other side was not appearing on 3 occasions, that NIAC matter, my lord.
Oh.
Actually, there's some problem regarding his
name was in
issue.
the first.
Oh.
Yes.
Another API.
met him today and then when we discussed
Oh,
this matter.
acha.
Now they have filed this IA, my lord, for they're seeking
August 2024, Lordship. That is at page 7 of the IPT. By his Lordship, 20% of the fine amount was directed to be deposited to the court. But that order was not complied till date.
So that order is already under challenge or no?
No,
Not.
No.
It is not.
No, I'll just tell you.
That's not challenge that order.
NIAC case was filed, my lord, by them.
Yes.
We got convicted. We filed an appeal. In the appeal, my lord, this appeal was filed on 9th of May 2024. So on 6/6/2024, during the pendency of the appeal, sentence was suspended and we were directed to pay 20% of the compensation amount by the appellate court. Now, under 148, ordinarily 2 months time is given, pay the amount. Now, on 6/6/2024, this order was passed on 10/7/2024. That is within 2 months of filing of the appeal itself was decided. So we could not pay this amount. Now they have filed this petition, my lord, and I'll obtain instructions from my client whether he wants to oppose this or whether he is ready and willing to pay this amount. Today this has come for the first time.
But you mean to say that without the payment of the 20%, the appeal has already been decided?
Appeal has already been decided, ma'am. Within 2 months of filing the appeal.
So now you're taking that plea.
Yes.
So you are raising that issue that the order of this payment was not complied with.
In the appeal, Lordship, the appellate court is directed to recover the whole amount. Against that, they have come to the
Before this court. Yes. So they have challenged the order of the appellate court. It's okay.
Fine.
Now why you are here in I criminal?
Before the pendency, I have filed the IO for 20% of the fine amount.
At this stage.
But if your lordship, once otherwise the case is ready for final hearing, readings are complete. Fix the date.
Yes.
As well, Lordship. Otherwise, this has come for the first time, so I don't have instruction on this part. I could take instruction on that part. Otherwise, your lordship can also fix it, admit it, and fix it for hearing. Because this order.
Now the question is regarding the admission. If he raised that issue, so you better to take.
I'll take instruction, my lord. Because if your lordship will see the order for a moment, my lord, order date at page 10 of the IA, my lord.
Yes.
The lordship will see that the convict is allowed to remain on previous bail subject to the convict shall deposit in court an amount of 20% awarded by the court within a period of 60 days. So this was on 6/6/24. Within 30 days, appeal got disposed of. There is no question. This is not a case of non-compliance on our part. The very issue was that appeal got disposed of, so we could not pay. So I'll obtain instruction.
You can do one thing at the time of suppose admission hearing.
Yes.
It's not yet admitted, I think. So you may raise that issue also either in the form of IA criminal or in that case also you can raise the same issue. That 20% 148 what is there in the provision. And in the meantime, you just take instruction.
I'll take instruction.
If he is ready.
Yes.
Then that order can be.
Yes. Then in that case there will be no dispute also, my lord. I'll just obtain
dispute also. Yes, that's why.
My lord will kindly fix it immediately after vacation. Then
immediately after vacation. It will take up the criminal revision petition to take up card Mr. S. Nawan, Learned Counsel for the petition, and also card Mr. M. Rana, Learned Counsel appearing for the respondent. Yes, after vacation.
16th, my lord, was some difficulty on hearing matter is there, my lord. Anything other than 16, my lord? 23.
23.
I'm deeply agree.
23/7.
Lordship, item number 23, Lordship, this matter I could not appear on time when the matter was called for. Now, Lordship, this matter has been fixed on 14th of July. Now I'm just praying for this some early date, Lordship, because this matter is on several.
Pass the order. And these 2 weeks, we have some difficulty also. Some day motion day will be declared, so many matters may come. Probability is there. So we are trying to list numbers of matters.